on Health and Human Services. It is Thursday, April 1st, and we're assembled around our virtual horseshoe and are live streamed on the HHS channel found on the Maine State Legislature's YouTube channel, where you can also find the replay of our proceedings should you miss us live. This morning, we'll hold public hearings on the following bills in this order: LD 78, followed by 739 and 792. For those testifying, please ensure the name you're using on the Zoom webinar matches the one you used when signing up to testify, and we would ask that in order to help our clerk manage the attendee list, you exit the webinar once you've finished your testimony and answered any questions from the committee, and watch the rest of the hearing live on YouTube. We'll be taking testimony in the following order: the sponsor, any co-sponsors or other legislators, those providing testimony in favor of the bill, followed by those opposing the bill, and then finally, neither for nor against, but with additional information for the committee. We run a 3-minute clock on testimony, and you'll receive a prompt when you have 30 seconds left asking you to bring your testimony to a close. Public hearings are just that, for the public. The process of hearing testimony certainly engenders and encourages probing questions, and the committee is asked to use the raise hand function in order to ask those bill-related questions. We'll do a quick round of introductions, and we will start with Representative Lemelin.
Thank you. Good morning, everyone. My name is Michael Lemelin. I represent House District 88, Chelsea, Jefferson, Whitefield, and half of Nobleboro.
Good morning. Representative Zager.
Hello, good morning. Thank you, Madam Chair. My name is Sam Zager. I represent District 41 in Portland.
Representative Griffin.
Good morning. My name is Abigail Griffin. I represent House District 102, which is Glenburn, Levant, and Kenduskeag.
Representative Craven.
Thank you, Madam Chair. My name is Margaret Craven, and I represent House District 59, which is part of Lewiston.
Representative Perry.
Good morning. I'm Representative Perry. I represent House District 140, which includes the towns of Indian Township, Baileyville, Bering, Calais, Charlotte, Robbinston, Pleasant Point, Pembroke, and Pembroke.
And Senator Moore.
Good morning. I'm Mary Ann Moore, and I represent Senate District 6, which is all of Washington County, as well as Goldsboro, Winter Harbor, and Sullivan in Hancock County as well.
So this morning, my co-chair, Senator Claxton, is delivering testimony on a bill in another committee. Our first bill before us is LD 78, of which I am the sponsor delivering testimony. And so I am going to turn over the chair responsibilities to Senator Moore to open up the public hearing on LD 78.
Thank you, Representative Hunter. I had to get up and move so that the lights would come back on in the room. Sorry about that. Yes, the first public hearing we're going to have this morning is on LD 78, which is an act to protect children from extreme poverty by preserving children's access to temporary assistance for needy families benefit, which is the TANF benefit. Our sponsor of this bill is Representative Meyer, so I will ask her to go ahead and introduce the bill to us at this time.
Thank you, Senator Moore. Good morning, esteemed colleagues of the Health and Human Services Committee. I am Representative Michelle Meyer, serving Southern Maine's House District 2, which is all of Elliott and parts of Kittery and South Berwick. I'm here this morning proudly introducing LD 78, an act to protect children from extreme poverty by preserving children's access to temporary assistance for needy families benefit. Currently, if one parent in a family receiving a TANF benefit is non-compliant with the provisions of the contract entered into in order to receive the benefit, the entire family is terminated from the assistance. This full family sanction leaves the compliant parent and the children without income to pay their rent, purchase basic necessities, keep the lights on. Under these circumstances, children in deep poverty are disqualified from a desperately needed assistance as a result of one parent's sanction. This bill would change that policy. Rather than remove the entire family from TANF, it would remove the non-compliant parent from the benefit calculation. For example, if a family includes 2 parents and 2 children, their benefit is calculated based on their income and the needs of the family of 4. If one parent is unwilling or unable to comply with the family contract, say mom doesn't participate in Aspire meetings or work requirements, the benefits would be recalculated for a family of 3, dad and the 2 kids. Under a partial family sanction, the non-compliant parent would be held accountable without punishing the compliant parent and children. Who are these families receiving TANF? Well, they are your neighbors. They are among each of the constituencies we serve. It's the woman working the register where you buy your groceries, or the young dad mowing lawns and studying for his GED. It's the single mom working toward a college degree with an eye on the prize, self-sufficiency. And at one time in my life, it was me. 31 years ago, I was a TANF recipient. Called Aid to Families with Dependent Children, or AFDC then, I found myself alone with 2 very young children, living in a small rental in a rural village, no job, few marketable skills, no reliable childcare, no family to help, no car, no savings, broke. With few options to keep us housed and fed, I swallowed my pride and summoned up the courage to apply for welfare. For a little over 2 years, I stretched every dollar and found ways to make never quite enough work for us. Any unforeseen expense or decrease in the benefit amount that I had not carefully budgeted for might have toppled our precarious existence. With an imperishable hope that I would find a way out of poverty and make a better life for my kids, I applied for and received a scholarship to nursing school. It was not long before I was gainfully employed as an RN. It was TANF that kept my little family afloat. It was never a handout. It was always a hand up. It stabilized us long enough for me to earn my degree and enter the workforce for a decades-long career in the caring profession, and a journey that led me into public service to a seat alongside all of you in the state legislature, and to this moment before this committee. Why do I share my personal story today? Because when we consider a change in policy, such as that we have before us in LD 78, it's important for us to consider precisely who the change may impact and how. That we understand that access to economic security programs has a dramatic effect on whether families in poverty can lift themselves out to successfully participate in the workforce. LD 78 strikes a balance between responding to individuals who do not comply with TANF Aspire program requirements, while without jeopardizing the health and well-being of the children and compliant adults who, under current policy, are punished through no fault of their own. I urge the committee to consider the vulnerable families you undoubtedly represent and to vote ought to pass on LD 78. I'd be happy to answer any questions, keeping in mind that there'll be those behind me who can answer some of the technical questions about current policy.
Thank you, Representative Meyer. Your story is very touching, for sure. I see a hand raised with Representative Craven.
Thank you, Madam Chair. thank you, Representative, for bringing the bill forward. I don't have any questions, but wanted to thank you for sharing your story and letting us know what kind of work we're doing today. Thank you.
Thank you, Representative.
Senator Claxton, I see that you have joined us. Would you be able to take over chairing this public hearing so that I could actually enter my testimony into the record?
We have a hot seat system going today. Yes, I'd be glad to.
Tag, you're it type thing, right? So thank you very much. Senator Claxton, Representative Meyer, and members of the Health and Human Services Committee. My name is Mary Ann Moore, and as you know, I represent Senate District 6, which includes all of Washington County and a few towns in Hancock County. I'm here to speak in favor of LD 78, which is the Act to Protect Children from Extreme Poverty by Preserving Children's Access to TANF benefits. Under current law, the Department of Health and Human Services terminates assistance under the TANF program to the entire family, including children, if the children's parent fails to comply with requirements of the family contract for a period of 90 days or for any subsequent failure, as Representative Meyer explained. This bill amends the provision to terminate benefits for the non-complying parent, but continues to provide assistance to the children and complying parents. As the state senator for Washington County, this legislation is of particular importance. The 2020 Maine Kids Count report indicated Washington County has the highest child poverty rate in Maine, with more than 1 in 4 children living in poverty. LD 78 ensures their basic needs continue to be met, even if a member of the household receiving TANF is a bad actor, or more often one parent is unable to overcome barriers to completing the requirements. Under this legislation, it is the non-compliant parent who would be removed from the benefit calculation, not the entire family. The pandemic has made this legislation even more important. Nationwide, the number of children in poverty has risen exponentially. This is certainly true for my constituents. Therefore, I hope you will support this legislation, and I would be happy to answer any questions that I might be able to answer. Thank you.
Thank you, Senator Moore. Are there any questions for the good senator? I don't see any. I will take a moment, if it's okay with the former chair, to introduce myself. I'm Ned Claxton. I represent Senate District 20, which is Auburn, Minot, Mechanic Falls, Poland, and New Gloucester. And I'm happy to be here, having survived agriculture, conservation, and forestry, and a bill I introduced there. And 2 more to go here today, so it's an interesting day. I see that there are additional people here to testify in favor, and I think I will go to who's here, Ms. Hasted. Good morning, Christine.
Good morning, Senator Claxton, Representative Meyer, members of the Health and Human Services Committee. My name is Chris Hasted, and I'm the Senior Policy Advisor at Maine Justice. We're a civil legal aid organization working with and for people with low income to improve their economic security through policy change, education, and legal representation. And we're here today to strongly support LD 78. I want to just start by thanking Representative Meyer and Senator Moore for your testimony this morning. It warmed my heart and I appreciate it greatly. Thank you. You've already heard what sanctions are, so I won't talk about that. But to be clear, I want to just talk a little bit about our experience with them. These breaches that result in sanctions are often the result of simple misunderstandings, clerical errors, or circumstances where good cause is not appropriately recognized. And over the years, we've helped hundreds of families regain needed assistance in circumstances like these. But many more did not get the help they needed, and as a result, their children and their family lost all of their income. But even in cases where there may be some degree of fault, the current penalty is greatly out of proportion to the action. Missing a meeting with a caseworker or failing to provide a required piece of verification doesn't justify taking food or shelter away from a child, which is often the result of this policy. Proportionality is fundamental to our principles of justice, and we ask you to apply that principle here. I want to just give you a couple of stories that illustrate what these cases really look like. The first is about a family that lived in a rural part of the state with no vehicle, and the mom was struggling to meet her work requirements because of that. She'd also been hospitalized on numerous occasions and missed a couple of appointments with her FedCap worker. FedCap wanted specific paperwork from her medical provider verifying her hospitalization and her health status, and he was busy and unable to provide that promptly. As a result, she was sanctioned and lost benefits for a period of time before we were able to step in and help her resolve those issues and regain her benefits. But by that time, she and her kids had gone without benefits for several weeks. In a second case, a mom with 3 small kids was sanctioned because her kids had been sick and she missed a couple of routine appointments at the FedCap office. To regain her benefits, she was required to go to 3 consecutive days, full days at the FedCap office doing a work requirement, which she was happy to do. But on the 3rd day, she had to leave early to appear at a child support hearing to try to regain her child support from her former husband. This interrupted her requirement and she was made to start all 3 consecutive days again, extending her family's loss of income even further. During that same period,
Christine.
thank you. During that same period, she enrolled in a training program, but was unable to begin that because she didn't have the childcare she needed. I know that you all know that there are thousands of children in Maine that are experiencing poverty. What you may not know is that only 1 out of 5 of those kids living in poverty receive TANF. That's lower than the national average. And the New England average is about double that. And so Maine has a high rate of kids living in poverty with no help from TANF. The last thing I'll say really quickly is that there's a lot of research that has taught us a lot over the last few years about the impact of TANF. You can read my testimony to learn about that. You may hear about that from other testifiers, but in a quick nutshell, it's very error prone, disproportionately impacts people with high barriers to employment, including mental and physical health issues, increases material hardship, and is found not to increase rates of employment among sanctioned parents. Thanks so much for the opportunity to testify this morning and for introducing this bill, and I hope you will all support it. Thank you so much.
And thank you. Are there any questions for Ms. Hasted? I don't see any, but again, thank you for being here. I see we've been joined by Representative David McCray. Welcome, sir. And the floor is yours.
Thank you very much, Senator. It's good to see you again. You were just over in my other committee, and I thought I would be chasing you here, and I am. Anyway, I am Representative David McCray, Senator Claxton, and Representative Meyer. Thank you very much for the opportunity to speak on this very important issue. I could expand upon all of the reasons why the kids in this situation really shouldn't suffer. And I'm sure there are going to be people that are going to be singing that song. But I want to point out a couple of things, and then I have a story or two to tell as a career educator. One of the things is that these children are not, they're going to be penalized if they lose benefits simply because of some snafu, either by the parents or eligibility or what have you. And I think these benefits for kids, especially young kids, young students, young kids, children, can't be overstated. It's not possible. The penalties would affect such things as food, clothing, school supplies, etc., which are all, critical to a child's life. The child has no ability whatsoever to fend for themselves in these situations. It's purely up to programs such as the TANF and parents, etc. So that's a really critical thing. I want to move without taking too much time to a couple of things that I think we can all relate to, and I think we all ought to buy into to think about. My favorite story regarding this has to do with an aunt and uncle and their kids in my own family some 40 years ago. And the child involved here is named Peter. And Peter was a less than slender little 4 or 5-year-old kid. And his dad worked over at Loring Air Force Base, and his mother worked for a law firm. And they juggled their work schedules so that there would be somebody home to take care of the kids, including an older sister, etc. So here's little Peter. And like I say, he enjoyed food. He really did. And he came, and his mother got home from work at 5 o'clock. And he was kind of moping around the house. And she said, "Peter, what's wrong?" He says, I think I'm sick, Mom. I really think I'm sick. And she said, "Oh, Peter, why don't you go lay down on the couch? Supper will be ready." "Supper?" He says, "Maybe I'm not sick. Maybe I'm just hungry." He had a little snack and he was just fine. My point of that story is very simple. You can picture little Peter thinking he was sick. Now picture little Peter in the 1st grade, and he comes to school that way. How in the world does anybody think that a kid, a young kid especially, is going to be able to take advantage of educational opportunities under those circumstances? It's not going to happen. Nobody could argue that, okay? So I think, to me, that's about as good a story as I could come up with to say, this is something that you can't take it out on the kids because of circumstances in the family. So if there's any way that we can tailor this so that it will protect those children, I think that's important. I also want to point out, let's suppose that Peter goes to school and his clothes are terrible, okay? Think about how the kids are going to treat Peter, okay? Think of that. I mean, this is a little kid, 3rd grade, 4th grade, 5th grade. Older kids, I taught high school all my life, middle school and high school. And it wasn't quite so severe there because I think as we get older, we kind of are able to withstand being hungry without losing all of our capabilities. Same thing with school supplies. Picture a 2nd grader that doesn't have anything, all the time having to say, "Miss Jones, I need a pencil. Miss Jones, I don't have this, I don't have that." And there's going to be a stigma attached to that kid. So I implore people that are going to be making decisions on this to consider those kind of very real circumstances. And again, keep in mind, we're talking about children. I'm more concerned about the let's say, birth to 12 than I am the 13 and on up. So I thank you very much for your time, and I'd be happy to address anything that you care to ask me.
Thank you, Representative McCray, and for your heartfelt testimony. Are there any questions of Representative? I don't see any. Thank you for being here. I'm going to guess that based on where the boxes are on my screen, that Representative Griffin hasn't had a chance to introduce herself yet. Is that true? She's all set?
We
Okay.
we did intros at the start of the
Well, I
meeting.
assume you did, but on the box, it makes it look like she was later getting here than some. Okay. Good morning, Representative Griffin. I just want to make sure you had a chance to introduce yourself. So now we'll go
My
to,
internet goes in and out.
okay. Now we'll go to Molly Bogart and then to Ms. Eglinton.
Good morning, Representative Meyer, Senator Claxton, members of the Joint Standing Committee on Health and Human Services. My name is Molly Bogart, and I'm the Director of Government Relations for the Department of Health and Human Services. I want to thank you for the opportunity to help introduce and strongly support LD 78 and express my deep gratitude to Representative Meyer for her strong partnership on this proposal, and to Senator Moore, Representative Perry, Representative McCray, and other co-sponsors for their support. Put simply, this important piece of legislation will ensure that children are not penalized for the actions of their parents. The existing temporary assistance for needy families, or TANF statute, and regulations require that when a parent does not confirm compliance with work requirements or attend regular meetings for more than 90 days, or has had a sanction in the past, the entire household will lose their benefits. This is referred to as the full family sanction, as you've heard. Most participants in the additional support for people in retraining and employment, or ASPIRE program, come back into compliance within 90 days. However, there are instances in which a parent may not, or guardian may not come into compliance within 90 days or does not comply on more than one occasion. This could include a case where one parent is in full compliance and participating completely in the program, but another parent who is, for whatever reason, non-compliant. In those instances, benefits are stopped for all members of the household, including children. The current full family sanction policy puts our children at greater risk of not having their basic needs, food, clothes, and shelter met. No child can or should be held accountable for the actions of their parent or guardian. As proposed, this would eliminate the full family sanction, meaning that benefits issued on behalf of the child or children, as well as those for eligible household members who remain in compliance with program requirements, would continue, while benefits for a non-compliant adult would be reduced or stopped. In addition, if both parents or the parent in a single parent household are not complying, then the household becomes what we refer to as a child-only household and continues to receive critical financial benefits to meet the needs of children. Income eligibility for the TANF program cash benefit is much lower than most assistance programs, and thus participants in the program are some of the most financially disadvantaged in Maine. In 2019, 13.8%, it's almost 14% of Maine's children were living in poverty, higher than all other New England states with the exception of Rhode Island. In 2019, there were 912 full family sanctions applied to TANF cases in Maine. Children in those households and some parents who were meeting their own program requirements lost access to a critical benefit based on the noncompliance of another adult in the family. Research is increasingly showing that full family sanctions can cause increased hardship and harm for families and children. We have an opportunity to do what's right by the children of Maine by correcting this policy, and I hope you will join us in supporting this proposal. Thank you again for the opportunity to discuss it with you. If there are any questions, I'm happy to answer them now. And the department, as well as the Office for Family Independence, can join you at the work session as well.
Thank you for your testimony, Ms. Bogart. It looks like Senator Moore has a question.
Thank you, Molly, for your testimony. I just have one question. Would this in any way affect any of our federal funding for TANF if we make this change?
No, it would not.
Excellent.
Okay. Are there any other questions for Molly? Thank you for that. And I'm sure we'll hear from you through the rest of the morning and afternoon. And next we'll go to Ms. Eglinton. If I see you're already unmuted, thank you and welcome.
Thank you. Good morning, Senator Claxton, Representative Meyer, and members of the Committee on Health and Human Services. My name is Stephanie Eglinton, and I'm Executive Director of the Maine Children's Alliance. We are a statewide, nonpartisan, nonprofit research and advocacy organization whose mission is to promote sound public policies to improve the lives of children, youth, and families in Maine. I offer testimony on behalf of the Maine Children's Alliance strongly in support of LD 78, which, as you've heard, reforms TANF so that children are not cut off from benefits when one parent or caregiver is found to be non-compliant with the program. As child advocates, we strongly support this change that will benefit Maine children living in poverty. Growing up in poverty can impact a child's life and increase risks for poor outcomes in health, education, and social and emotional development. Of the 33,000 children in Maine living in poverty in 2019, over 12,600 children were living in deep poverty. This means they live in family incomes below $12,875 for a family of 4. This is less than 50% of the federal poverty level for a family of 4 of $25,750. Due to systemic and historic inequities, children of color and those in rural areas experience higher rates of child poverty. At its core, TANF is intended to ensure that children do not go without basic essentials. It helps fill gaps during difficult times and provides parents with the tools they need to get and maintain a job, keep their homes, pay their rent, and put food on the table for their families. The COVID-19 crisis has been one of the most difficult times for thousands of Maine families. Comparing December 2019 to December 2020, TANF enrollment increased by 525 children, from 6,690 to 7,200 children. As you've heard here today, research has shown that strict full family sanctions cause harm to families, and especially those with the greatest challenges and those most likely to be in deep poverty. LD 78 will improve the TANF program and make it more effective in helping children and families address the challenges of living in poverty. So I thank you for this opportunity to testify and for your consideration of this.
Thank you, Ms. Eglinton. Are there any questions of this testimony? I don't see any. Thank you again for being here. Now we'll move on to Ms. Rogers.
Good morning. Good morning, Senator Claxton and Representative Meyer and esteemed members of the Health and Human Services Committee. I'm Dr. Victoria Rogers, and I'm a resident of Saco, and I'm here to offer testimony in support of LD 78, an act to protect children from extreme poverty by preserving children's access to temporary assistance to needy family benefits. I've been before you before as the Senior Director of Let's Go, and I'm also a pediatrician at the Maine Medical Center, Barbara Children's Hospital. I just want to spend a minute saying that about Let's Go, we work with about 1,800 sites across the state of Maine, trying to increase healthy eating and active living. And things are really working. The folks in the communities are doing great work. But I also know, even though I'm very, very proud of the Let's Go results that we have to date, I know our families need a lot more assistance, and that's exactly what TANF does. And as a pediatrician, I know firsthand how important it is to ensure that children whose families suffer in poverty have access to TANF assistance. As you've already heard, it's an important safety net for families and children, providing many of the critical assistance that you've heard. But as we also know, for some families, TANF assistance from time to time, the assistant life gets hard for them from time to time, and they can't comply with the contract. And then this means that the whole family loses the benefits. As you've heard before, this doesn't make any sense to me. As a pediatrician, we need to end, as what TANF is supposed to do, is to bring children and families out of poverty. And by taking away the assistance for the children, this does just the opposite. So it doesn't make any sense to me at all. I strongly support LD 78, and I also acknowledge that the adult that would have his or her benefits terminated if they, don't comply with the contract. However, it upholds the intent of TANF, which is to help move children and families out of poverty. The safety net for children is so important for their development and their health, and we all know the health of our children helps ensure the health of our communities. For these reasons, I wholeheartedly support LD 78, and thank you for your time. I'm happy to answer any questions.
Thank you for your testimony. Are there any questions for Dr. Rogers? I don't see any. Again, thank you for being here and taking the time to testify.
Thank you.
As I understand it, there are no other people here to testify for or against, and none neither for nor against. So that will conclude the public hearing portion on LD 78. We'll be scheduling a work session in the future to see if we can approve a bill. So that's to come. So now we'll move to consideration of LD 739. And I see that Representative O'Connor is joining us. Welcome, Representative O'Connor.
Good morning. How are you this morning?
I'm fine. It's nice to see you back in HHS.
I am really glad that it's you guys, not me this time, but I certainly do miss you.
Well, my ribs are much happier since we're not sitting next to each other and you're not jabbing me with something to say.
You liked it, admit it.
You want to introduce LD 739?
I would be happy to introduce it. Let me get the right page here. Thank you, Senator Claxton and Representative Myers. I am very, very happy to be presenting this bill to you. I am speaking in qualified favor of this bill. However, I do have some questions that I hope that will be answered by the experts on this. And basically, I think you can read the summary of what it says, so I will not repeat that, but I will tell you that I did put this bill in for a Mr. James Lebrecht and the Getchell family foster home after their plight had been brought to my attention. And I won't read the whole story on what has transpired, but I did send a separate email to each of you so that you could understand what has happened. And I'll just continue and I'll keep this testimony slow because or fast, because I know that a lot of people will want to testify and actually tell you what this story is. The attorney that I work with, attorney Andy Slater, will speak, as well as Mr. Lebrecht, and they will explain what we wanted to do. What my concerns are and continue to be are with the intellectually challenged individuals who to this day have been forced into soup lines and food banks and have had services withheld because the foster home in which these individuals live in was denied financing. I believe the Getchell family is actually still caring for these individuals at their own expense, and they can explain that also. If there is a way to mitigate these problems faster and help these individuals, that would be really great. And I really think that we need to prevent this from happening again. And I think that working this bill appropriately would be well worth the effort. That being said, as I said before, I'm not sure that this bill for a rule change is penned correctly to address the issue and may need to be adjusted in the work session to reflect the intentions that I just previously stated. As you know, I'm not an attorney and I do not play one on television, and I prefer to rely on those that are the experts. But from what I've been told, it seems to me that no one can prove fraud if the state doesn't have to disclose what the fraud is, and one should have the right to know what fraud is being charged and have an avenue for restitution. And I thank each and every one of you for your service to this beautiful state. And eventually, when we get to see each other again, I will bring you cookies because I make them really, really, really well. Thank you. And I'm happy to take any questions. But as I said, Attorney Slater, as well as Mr. Lebrecht, can probably answer them better, as well as I believe Wayne Getchell from the foster home is here. And those individuals, I just want to let you know that each one of those individuals, some of them are intellectually challenged, therefore they are on Mr. Lebrecht's computer screen today. And I didn't think that was a problem considering the ADA. And I thank you, and I'm happy to take any questions from you.
Thank you very much, Representative O'Connor. Are there any questions for the representative? I will say that I took a quick look at my inbox and looked on your name, and I don't see the letter you referenced. So if it's being posted to the committee site, that might be something different, but I didn't see an email.
No problem. And if I do get that, Senator, if I do, I'll see if it hasn't been sent yet, and I will make sure that you have it, because knowing the backstory on this is actually really important, because if we're going to fix a situation, we certainly need to make sure that the language is correct. Thank you, Senator.
Thank you. Next, I guess we'll go then to Mr. Lebrecht and Testimony Central. It sounds like there's a number of folks there who want to testify. Welcome, Mr. Lebrecht. If you want to unmute yourself and join us.
There we go.
There we go.
Thank you. Thank you very much for taking this. It's fairly complex. I've been dealing with DHS matters, especially in the child protection arena, and special for, dealing with special needs people. I have a 37-year-old son that has been in the system all his life, so I'm fairly familiar with this, and I've been an advocate for many years across the state dealing with these matters. I'm going to step off, and I'm going to testify a little further down the line, but it was easier for everybody with all the special needs we have with their spokespeople and everybody to just come right here at my shop and then all be heard. So the one that we had first on the list, if it's all right, is Mr. Attorney Slater. And I'm going to give up the chair for Mr. Slater. And after that, if it's all right, I had given the clerk through Representative O'Connor a list of the names. And if we could go down to that list, if everybody's in agreement with that, we can make this move along as quick as possible. We'll just change seats. So is that all right with?
We have the list, and it's good that you can testify in this way. Yes, go ahead.
Yes, very good. So I'm going to introduce you to Attorney Andy Slater.
Yeah. Welcome.
Oh. Just one moment, please. Oh, that's us. Yeah, just leave it there. Well, do it this way. Can all you folks hear me?
Yes.
Okay. Thank you, Madam Chair and members of this Health and Human Services Committee. It's an honor to testify or provide information for you today. My name is Ferdinand A. Slater. I'm known and recognized as Andy Slater. I live in Hancock, Maine, and I support this bill because this bill is to make clear that if credible allegations of fraud are established, the suspension might be continued, modified, or ended at the sole discretion of the department. Just a quick note about me so that the committee has some background. I've spent 33 years defending this nation and those most in need of defense and protection as a member of the military in times of peace and war. I've got over 20 years experience representing children and parents in DHHS child protective matters as both attorney and guardian litem. The bill as presented is to hopefully fill the void and make clear to the department is not fulfilling the legislative intent of this statute, meaning 22-1714E, by ignoring paragraph 4. I reference for the committee's information, the letter in opposition sent by the department this morning, indicating specifically that the only issues at the hearing on a credible allegation of fraud is the issuance of whether there was a credible allegation of fraud and whether there is reason for the department to suspend the suspension.
30 seconds.
Say again?
That's your 30-second heads up.
Oh, okay. The department is not listening to and giving no voice to the most needy consumers, those intellectually challenged to the process, and they are not referencing by their own communication to this committee that paragraph 4 exists, therefore rendering it superfluous and avoiding and disregarding the legislative intent of establishing fraud and seeking to recover or retain suspended amounts. They never reference and never allow testimony before a tribunal of financial responsibility or wrongdoing, only a probable cause that an allegation may be credible. And that's unfair to Maine's most needy citizens, the intellectually challenged that are forced to either give up their constitutional rights of free association, living where they want to, doing what they want to, or being deprived of assistance by the state that they are certainly eligible for. This practice of the department puts Maine's most vulnerable and needy citizens in a position where they've had no voice, and the department has not, in this case or any other, interviewed or questioned the consumers as to what services they need. All of the providers are providing services. All of the reports are being provided by the providers to the department through team meetings and other requests for information. So there's no doubt these services are being provided, and the department is not listening to and is actively requiring the constitutional rights of these individuals be ignored and not. They either have the money or they give up their constitutional rights, which is unfair and not the intent of this committee or this legislation. Thank you.
Thank you for your testimony. Thank you for your testimony. And I see there's a question from Representative Meyer.
Yes, thank you, Mr. Chair. Mr. Lebrecq, have you submitted written testimony, sir?
That's Mr. Slater that's testifying right now.
Attorney Slater.
Yeah, it's Attorney Slater.
Oh, I'm sorry. Attorney Slater, have you submitted written testimony?
I have not, Madam Chairman. Chairwoman.
Do you intend to?
Yes. I was talking so fast 1 moment.
Thank you. That would be helpful. This is a complicated issue. We want to get it right. So if you can submit that in for our committee to review for the work session, we'd be grateful.
I can submit it by tomorrow, close of business.
That sounds fine. That sounds fine. It looks like on the list that Erica Greer is the next person to testify.
Hello.
Welcome, Ms. Greer.
Dear Senator Claxton, Representative Meyer, and ladies and gentlemen of the Joint Committee on Health and Human Services. My name is Erica Greer, and I'm the sister and guardian of Wendell Lapointe and Donna Poyer, two of the clients that reside in the Getchell Foster Home. I'm here to testify in favor of LD 739 because the statute as written has allowed the state to cut off all funding to Donna and Wendell's residents without proven violations, which in turn violates the health and safety rights of Wendell and Donna. I'd like to just take a minute to tell you briefly about each individual. Donna is a nonverbal woman who is severely autistic with severe epilepsy. As a child, she had behavior so severe, no one was willing to care for her. At 14 years old, she was institutionalized. Her biological parents moved south and continued on with their lives without her. At 18, my parents, Wayne and Rena Getchell, brought her home to live with us and join our family. Donna's caseworkers told us that she was unable to love and would never be able to be integrated into a family setting and would never tolerate being brought out in public. My family fell in love with her light blue eyes and told the caseworkers, with love, anything is possible. 31 years later, she still lives with Wayne and Rena. Although she requires total care, she is happy, healthy, and no longer a danger to herself or others, all because love made it possible. Wendell was 6 years old when he came to live with my family. That's 30 years ago. He was carried in and placed on our couch by his caseworker. He never made any attempts to communicate and could not ambulate without maximum assistance. He wore a helmet because of self-abusive behavior and severe epilepsy. The caseworkers again voiced their concern about integrating him into our family. Wayne and Rena again told the caseworker, with love, anything is possible. 30 years later, he too remains total care, but Wendell walks, runs, and often plays with my children who call him uncle. And Wendell has many means of communication. He is thriving, all because love made it possible. As of January 7th, 2020, over a year ago, the department has cut off all funding to the Getchell foster homes based on vague allegations that were made by an unknown source. DHHS has cut off funding to these clients without any notification or clarification as to why. Bi-weekly critical funding for daily care was subsequently interrupted. DHHS cut off this funding with no plan in place, forcing them to wait in lines at soup kitchens and food banks, and the oil tank only able to be filled by the grace of our local church. The state is in violation of many of the disabilities' rights by stripping their sole caretaker of all means to be able to support these individuals. I have reviewed the department's complaint and feel their unsubstantiated allegations in no way outweigh the justification for jeopardizing the health, life, and safety of them. For over 30 years, the Getchell Foster Home has provided the highest quality of care to individuals with severe intellectual disabilities. They cared for the ones that everyone else deemed unlovable. They have given them a place to call home and a family to call their own. I fear that if these issues cannot be resolved, these clients will be forced out of the only home they have ever known and will be forced to leave the only family that has ever shown them love. If this is to happen, I'm sure this will negatively affect their health and be detrimental to their life. Thank you for the opportunity to discuss this with you guys.
Thank you for your testimony. Are there any questions of Ms. Greer? I don't see any. Thank you for being here. Next up is Wayne Getchell.
Good morning.
Good morning.
Dear Senator Claxton and Representative Meyer, ladies and gentlemen of the Committee on Health and Human Services. My name is Wayne Getchell. My wife and I have been foster parents for 31 years. I'm here to testify in favor of LD 739 because the statute as written has allowed the state to seriously harm my family and violate the rights of the foster adults we've been taken care of for 31 years. I earned a perfect record and have never had a complaint against me until January 2020, which is a false claim of fraud. LD 739 is needed to prevent the department and the AG's office from acting in a defaulted manner under color of law and bad faith. In January 2020, the state, through the region's office, the DHHS, made claims of fraud against me, but they, more than a year later, refused to tell me how much they are claiming is fraud, whether it's 5 cents or $5. During the administration here in the department under oath testified that they did not know the amount of money at issue. I can assure you this committee that I never committed fraud in 31 years, but I can assure you that the department and the AG office has not been working in good faith because LD 739 is not in place. If the department was working in good faith, they could have simply taken any concerns they had and discuss it with me, not play the games they are cutting off 100% of the funding for these special needy individuals with severe disabilities during the pandemic. No food, no heat, no transportation, only help from food cupboards and donations. The department and the state have used the loophole that LD 739 will fill to prevent them from destroying more foster parents like me, my wife, and many disabled people as they have done over the years. I have no doubt that this is This complaint is an offer and effort to strengthen on more my wife and family, being strong and advocate for disabled. We care for grew longer over 31 years. AAG Moncure's hatred towards my wife allowed her to personalize her goal, destroy our family, and disable have become part of our family over the last 31 years. On this note, after this hearing, I would like someone on this committee to make motions to have an investigation done on the department and AG office. Thank you for listening to me today. Please fix one of the problems by passing LD 739. Thank you.
Thank you, Mr. Getchell. Are there any questions for Mr. Getchell? I think I'd like to make sure we're keeping the testimony specific to the bill and what we need to fix to make things work better. So thank you for that. Next is Emily Michio. Welcome.
Emily is going to have an interpreter helping her out. Emily is going to say hi and state her name, and then she'll have Travis help her out.
Hello, Emily.
Hi. And I am here to testify in favor of.
Is Travis going to help you?
Yeah.
Okay.
Can you testify against favor of the LD 739?
Welcome.
Welcome. Because I have been abused by the state because of LD 739 is not in place to protect my rights. I am 33 years old and a self-guardian with severe disabilities that has been completely cut off from my rights to live where I want to be, there whom I want, and to enjoy the benefits of the funding of my food, shelter, and heat. Because I refuse to live the home that I have a right to live in this state, and my caseworker threatened my dad that if he didn't force me to leave my foster home with Wayne Getchell, they would take all my funding and benefits away under Section 21. I was forced to move against my will and against the laws to protect my rights. They did not PCP plan in place as required by law to move me because I got a power of attorney and advocate to help me. My case worker who has been working against my rights quit and left me with no case manager. The state and my new caseworker, I believe, filed a false criminal complaint against my power of attorney in order to try and scare him into giving up on helping me. That investigation was closed by the Bangor PD. They were trying to violate my rights to a power of attorney and advocate. If LD 739 is passed, funding to get me back to the home I want to live should be in place, and the state will not have a stronghold on abusing me by wrongfully holding back on my funding. I am
30
asking,
seconds, Travis.
I'm asking this community to have a real investigation on the behalf of the state DHS office and AAG in charge of stopping our funding, and my old caseworker that has brought LD 739 to light. Thank you for listening to me, and please help protect our rights.
Thank you, Travis, and thank you, Emily. Are there any questions? I don't see anything. So thank you for being here. That brings us to Rena, Ms. Getchell, Rena Getchell.
She's not going to make it, so we're going to move on to Donna Poria. But Erica, who is her guardian, Erica, who is her guardian, is had to leave to make it to Portland. She was running late, but I'm going to just point out to Donna, who is here. And,
good morning, Donna.
And Donna is completely nonverbal. Donna is total care. She can't prepare any food or go to the bathroom by herself. She's in diapers, and she's completely 100% total care. Erica talked about her as her sister, and Donna has been cut off from all funding for well over a year, and this has devastating impact. I want to say one thing on behalf of Donna, and that is, if Donna was moved, she would be so devastated that she would go into major seizures, be hospitalized, and we're really fearful of even death in her case. That's why the Getchells have done everything they could to hold these people and keep them as safe as they could. This is not simply a matter of moving, Donna, like you would move a car. This has very serious human implications. Then I think the next one, I'll just make a comment, and then Wendell, come here, please. Where's the seat? Yeah. Wendell, sit right here, okay? Wendell, can you say hi, Wendell? Hi. All right. Can you tell him your name? No? All right. Wendell is nonverbal also. Wendell suffers from major seizures. They've had him under control for a long time, but just when the state comes around, Wendell gets so overwhelmed and so scared that he goes into seizures. He hasn't had seizures in a long time, and since this, it's been having a major impact on him. Again, Wendell would be severely harmed if the Getchells were to just let these people go into some strange home in the backwoods of Maine someplace. They would end up being hospitalized, and this would be a real front page news humanity problem. So Wendell, thank you for coming. Can you wave bye to them?
Thanks for being here.
Thank you for allowing us to do this. Now, Christopher Goldsmith is a little too much he's total care, and he's all folded up with his legs and arms all crossed, and he just sits and rocks, and with taking all the people down here was a big effort. And Christopher Goldsmith, I'm his legal guardian, legal guardian. And Chris is another one where he was bounced around from home to home, and until he got to the Getchells, he was in severe medical distress and hospitalized. These people here all three of them would be seriously harmed if they had to move. And the department is trying to cut off funding to force them to move. If they succeed, then somebody's going to have blood on their hands. That's all I'll say about Chris Goldsmith here. I'll testify on behalf of myself here. Now, my name is James Lebrecht. I'm from Bangor. I have a disabled child, Lariano Lebrecht, for over 37 years. I'm a single dad that has raised Lariano by myself. He's total needs also. He can't use the bathroom on his own. As a matter of fact, bring on over here. I'm going to set him. Yeah, over here. Okay. We're going to just flip the camera and let's see if I can get it. There we go. There we go.
Hi there, Leon.
There we go. So let me, in my 30-something years of working with the department, I can tell you that the department always has an advantage over these caregivers. And if they don't do what they want, then they punish them. They use them as an example. This is nothing new in this case, but this case we're bringing to light.
Mr. Black, how will this bill help this situation? I think that's what we'd like you to speak to.
Okay, so the bill, what they're doing is they're using the fact that they don't have to make any claims to how much money is being claimed as fraud, even after a hearing. In the testimony, the state says, we don't know. And I want to bring up just the 3 claims that they made, and there's 2 questions to that, is how much money in each one of these claims that they're not telling us that we cannot wait for until after appeals and so forth. We need to know before to clean this up. This has been in court now, or administrative hearing, and waiting to go into court for over a year. And let me just set the foundation, because I'm sure everybody's wondering about this. There were 3 very simple claims. Representative O'Connor put those in a letter to you. I guess you guys must have just received it this morning. It had claim 1 that they were claiming against schedule may have been billing for services not rendered. They don't say how much. I can guarantee you in 31 years that I've dealt with this family, they have never in their life even considered cheating anybody. But then the claim 2 had one of its clients provide services and take care of other clients in the home. They're saying that one of the special needs was helping some of the others, so therefore that's a violation. That's a labor issue. There's no claims here. There's no money. They're holding back $940,000 right now from these people based on those 2 claims. And then the 3rd claim is concealing that an excluded individual, Rena Getchell, is providing services and it's taking care of Getchell foster home clients, then is building main care. They have not one number for that. And here's where the rights get in. So they won't tell how much money for each one of those things. And even if they could make some kind of claim, it would probably be a few $1,000s that they could correct. But here,
30 seconds, James.
okay, so here, instead, they're violating the rights of these people. In that paper that Representative O'Connor gave you, she really has, she has this whole thing written up with the claims and everything in it. And if you read that and you ask yourself, why is it they're holding back and causing these people to be in such serious jeopardy for hardly any money at all, even if those claims are true, which we deny are not true. But that Bill 739 is preventing them. We can't ask them how much money and to come forth with the money until after 31 days after the hearing, after an administrative, after administrative hearing, where we have to file an appeal within 30 days. And that's screwing things up. They should come forth with the money on how much money is being, and I just want to say one more thing in closing. The state did not take into consideration with Ms. Getchell and being a excluded provider, that she is the mother of these people for 31 years. That's their home. That's their mom. she isn't getting paid to take care of them, but because she was in the same house, they're claiming that would be fraud. That's not fraud. That is their right to be living together, continue living together. The state has stepped way over their bounds and say if she's living there, then that's fraud. And it is not fraud. They have a right to, these individuals have a right to be and associate with who they want and live with the way they want. The state is way out of control on this.
We will be considering the letter from Representative O'Connor and the testimony that's been submitted when we get to the work session. I understand that the bill would speed up the process of people being informed about the concerns. And it feels that that would address at least some of the issues that you all have with the state. Is that correct?
Yes, it's just one of many loopholes that the state has to put pressure on people to make them behave how they want. I'll tell you, the foundation for this is that the Getchels have been the most fierce advocates for these special needs people. And the state doesn't like it because when the state's in the wrong position and you advocate for these people, then they circle wagons around you. And this is, so that's what's going on here. And they're using this law as a means to try and kill them off. I'm going to not fund them. There's no reason that you have to go along over a year for these three little things that they're making claims to. That could be taken care of in one meeting, but they're trying to bring it up.
We'll get some lawyers to look at the bill language and look at what's there in the law now. And we'll see if there's an opportunity to make things work closer to the way you want.
And I'd like to have Mr. Attorney Slater part of the workshop if that's possible.
This is a public workshop and anybody's invited to watch the process.
Thank you. And thank you all for participating. This went better than I was hoping. And I want to thank you very much. My heart is out to these people. I don't get a penny for anything here. I'm very concerned about what's going to happen to these little lives. And the department is thank you.
Thank you again for being here and for bringing the extended members of the household and family together.
We forgot, there was one we missed on the list. Travis Getchell has his own little testimony. And then we have one other person, Lena, that had came in this morning. But Travis has a written testimony. We're going to be filing those written testimonies. The clerk was nice enough to send us the link. So Travis, come up, and then afterward, Lena, then we're done. Thank you. Did we have a read? Go ahead, Travis. No, you do your thing.
Hi.
Is this Travis?
Yes.
Welcome.
Well, thank you. Dear members of the community, my name is Travis Getchell, and I am here to testify in favor of LD 739 because it has been one more way for the state to abuse me, but my family and my friends. I am 36 years old with a qualifying disability under the ADA. My parents have been caring for 5 individuals with disabilities since I was 5 years old. I have a special relationship with someone with disabilities, Emily Mishu. The state has abused our rights to associate on numerous occasions to
Mr. Getchell,
Yes.
This bill won't address that concern.
Okay. Well, okay, I have, associate. My advocate had to help defend Emily and me from the state abusing our rights. I have a video my advocate shot when he came to defend our rights from being abused by the state and Sweetser. Simply, the state and Sweetser tried on a number of occasions to tell us we could not be together, and told Emily and I that I was not allowed to be in the area of Bangor where she lived. With they had no right to. They didn't this because they wanted to hurt my mom by hurting us because they do not like my mom. Excuse me.
Mr. Getchell, I'm sorry. I'm sorry this is so hard, but we really need to better understand the LD 739 and how it might help you. We're not spending much time talking about the bill.
He has his written testimony, so we'll send that in. Okay.
Thank you very much.
Yep. No, that's right. We'll be sending that in. Okay. Then move on to the post. Yep.
Hi, thank you for the opportunity to speak today. My name is Lena Ramsey. I am from Mariahville, Maine. I had the opportunity to witness and assist Attorney Slater in the proceedings that are brought to light here today. I support this bill because as a citizen of Maine, I'm outraged not only at the inference of a bias in this case, but also the complete lack of accountability and common sense of the department. I'm concerned that we are forgetting the essential needs of truly innocent individuals. There should not ever be a bias or a lack of accountability by a department such as this. If I'm making an allegation of fraud, it isn't only common sense that the amount of that alleged fraud be specified by the department that is making it. My concern goes above and beyond the case that we are discussing here today. There must be basic accountability, or truly innocent people, such as what you've heard today, will continue to become victims in the future by a department such as this that is currently operating in an unacceptable fashion. It is my understanding that the introduction of this bill can change that. Thank you for allowing me to speak today.
Thank you for being here. Are there any questions for Ms. Ramsey? I don't see any. All right. So this will conclude the.
Wait, we have one more disabled person that was here. I guess I missed her on the list, and she's going to be speaking for herself. She's more vocal. Her name is Maria. What's your last name? Okay, tell her your name. Okay.
Hello, good morning. Good morning. My name's Marie Jones. I am 60 years old, July 5th. I have moved from a very abusive agency, Sweetser, that had beaten on me, left me in poop and urine that I had laid on in for 4 days. I was locked in my room. I was very sick. They left me 21 days with no meds or insulin. They would not take me to the hospital, the doctors, until I was so sick. I died twice in the ambulance. Reportables was done by Joanne, my caseworker, in crisis. Nothing was ever done. I'm sorry. While I was in the hospital, Wayne Ghetto got a call. He came to see me. I begged him to live in one of his homes. He told me that I was my own guardian and I had rights to choose where I would live. I know that, but the state always took all that away from me, and the state advocates.
I'm sorry. This isn't really a hearing on how department is performing. We need to know about your testimony related to the bill and how that would be helpful to you.
I think she was trying to set the foundation for, if not for the fact that that bill has allowed them to hold back funding this long, this type of stuff would not have gone on. I think she's trying to show you the causation of this bill the way it is right now, to string them off for a year and a half with no money. And she is the one that went to get food stamps, and the department said, no, we can't give you food stamps. You don't qualify.
So I think it seems to me there's several issues here. One is the LD that we're allowed to touch or do anything with, which is 739. And the other is what your options are with respect to your relationship with the department. And we really can't do that. We may have some suggestions after our public hearing. We may come up with some ideas that we could give to Representative O'Connor, but this is not a hearing on the department's behavior, other than we understand that you think LD 739 will help.
Yeah, that's good. I think we're all set. Okay. At least you have the good feel for what these people's concerns are to the best of their abilities under the ADA. Thank you so very much, and you did a very good job. You got your point across already. Tell them, say thank you.
Thank you very much.
All right.
Thank you for being here.
And my dad.
All right. So we'll now move to additional testimony. I don't see anybody else who's testifying in favor. I understand that Mr. Erb is here to testify against.
Good morning, Senator Claxton, Representative Meyer, members of the committee. My name is Rick Erb. I'm the president of Maine Healthcare Association. We represent nursing homes and assisted living facilities in Maine. I have submitted written testimony. I also have sent on behalf of John Doyle at Pretty Flaherty some of his analysis. I won't read my testimony. I know we're running a little bit behind. I would just say I believe that the issues that my association has are really more unintended consequences of the language of the LD 739. Our concerns are that it would allow DHHS to withhold payments based on allegations as opposed to anything that has been proven. We'd be very concerned about the position that would put facilities in. It would put them in financial danger. It also eliminates appeal processes that are already in place and eliminates fundamental rights to judicial review. So those are the issues that we have with it, not with the merits of what was attempted here, but as we've already heard from the sponsor, it's suggested that there may need to be more work done on this bill. We would ask if we could be involved in those discussions, if Mr. Doyle from Pretty Flaherty could participate as well. And we would like to make this work and accomplish what was intended without preventing people from having rights of appeal and due process. But I'm happy to answer any questions that you may have.
Are there any questions of Mr. Erb? And the answer to your query is, of course, anybody who'd like to join us at the work session is welcome. If there's some amended language that you all would like to submit before, we certainly could consider that. Getting it before would give us a chance to get familiar with it. So yes, we'll keep you posted as to the next work session. I don't see any other questions. I don't see anybody else who wants to testify against or neither for nor against. So we'll thank Representative O'Connor for bringing this forward, and we'll conclude this public hearing portion of our considerations of LD 739. Are there any questions we'd like to put to the analysts, that information we'd like to have in anticipation of the work session? Yes, Representative Perry. When you're off mute, we'll be able to benefit from your wisdom.
I would like to get from the department what the usual process is that they use when something comes forward and what the timeline sort of looks like and in terms of the department's responses and the responses that are possible for the person or the facility with the allegations.
Thank you. And Representative Craven, you had your hand up?
Thank you. Representative Perry asked my question.
Great. Okay, and we'll understand in anticipation of the work session that will be limited to considering information about general procedures and not the specific instances, the specific instance that has come up in this conversation. Is that enough to go with, Ms. Zuling?
Yep, I'm all set. Thank you.
Okay, all right. Yes, Representative O'Connor.
I really wanted to thank this committee for listening. I know this was highly unusual, and I do look forward to working with Mr. Erb as well as Diane Johansson and the Maine Hospital Association. They did have some concerns I thought they would testify against, and I just want to thank you and thank you for your patience and for working with me in this issue. Thank you so much.
Thank you. Appreciate the comment. All right. So that'll conclude the public hearing portion of LD 739. We'll move on to LD 792. Before we do that, I'm going to hand off the chair to either Representative Meyer, if she's available, or there she is. Are you good to go take over?
I am, Senator.
Yes. Okay. Let me make sure I have my testimony.
Okay.
I think we're now on to 792.
Yep. Testifying on LD 792, an act to make technical changes to the eligibility provisions of the Higher Opportunity for Pathways to Employment program, is its sponsor, Senator Claxton. Take it away.
Thank you, Anu, and good morning still, Representative Meyer and honorable members of the Joint Standing Committee on Health and Human Services. As you well know, I'm Ned Claxton and represent Senate District 20, which includes Auburn, Mine, and Mechanic Falls, Poland, and New Gloucester. I'm here today to introduce LD 792, which is an act to make technical changes to the eligibility provisions of the Higher Opportunity for Pathways to Employment program, also known as HOPE. This program helps students and their families reach their educational goals by helping cover costs related to school in the postgraduate portion of their education, whether for a short-term training certificate, an associate, or a bachelor's degree. The HOPE program helps students advance their education. To qualify, financially, the individual or the family must be at or below 185% of the federal poverty level. This is to help people who are struggling out of poverty. I present this bill at the request of the Department of Health and Human Services. It makes two changes to the current rules related to the HOPE program. It makes acceptable fields of study for participation will now be determined by the number of job openings rather than the phrase job outlook. This changes the criteria for determining acceptable fields of study and is used by the Center for Workforce Research and Information within the Department of Labor. The bill also provides that the department rules must specify at a minimum that the fields of healthcare, technology, engineering, and education in the provision governing approved post-secondary graduate four-year degree programs. The expectation is this will help the program better contribute to focusing on meeting Maine's future job needs. I leave it to the representatives from the department and further conversation to describe the program and the benefits of these changes as needed. Thank you, and I will be glad to defer any questions to the experts.
Thank you, Senator Claxton. So we will turn to the expert from the Office of Family Independence. Mr. Pilat, please unmute yourself. Welcome.
Good morning. Thank you for calling me an expert. I appreciate that. Senator Claxton, Representative Meyer, and members of the Joint Standing Committee on Health and Human Services. I am Anthony Pilat, Director of the Office for Family Independence for the Department of Health and Human Services. I'm here today to introduce and testify in support of LD 792, an act to make technical changes to the eligibility provisions of the Higher Opportunity for Pathways to Employment program. We thank Senator Claxton for sponsoring this department bill. The HOPE program helps qualifying parents cover costs related to training and education in specified fields that are intended to provide opportunities to families and meet workforce needs for the state. This proposal seeks to clarify language and expand the eligible degree programs within the Higher Opportunity for Pathways to Employment program. The proposed changes emphasize the relationship between the workforce development opportunities of the HOPE program and fluctuating employer needs in Maine by utilizing 1, consistent language on employment expectations of fields of study that will be supported by the program, and 2, by adding education as a supported 4-year degree program, as well as providing the department the authority to identify additional eligible programs through rulemaking. This change would allow the program to more nimbly respond to workforce needs in the state. Currently, the HOPE statute designates 4-year degree programs in healthcare, technology, or engineering as the bachelor's degree majors that result in high-value credentials and may receive HOPE program support. This bill adds language which requires the program to expand acceptable bachelor's degree programs to include the field of education. This bill will also allow the department to designate and rule other eligible degree programs to respond to changing workforce needs. The number of possible enrollees in the program remains capped at 500, so this change will not require additional funding. Additionally, this bill will clarify 22 MRSA Section 3790A, which governs the HOPE program. The law specifically refers to the Maine Department of Labor's Center for Workforce Research and Information, CWRI, as the accepted data source relative to Maine workforce needs. HOPE staff, applicants, and participants utilize the CWRI data to determine which certificate or degrees will be valued by Maine employers. LD 792 would change the term job outlook to job openings as a standard to determine appropriate training pathways. This aligns the HOPE statute with the terminology and standards used by the Maine Department of Labor and the readily available data provided by the CWRI. These changes would provide more opportunities for parents with low incomes to access education and training in fields with immediate workforce needs. This change also benefits the state by increasing the number of qualified workers in much needed sectors. We hope you will support the passage of LD 792. Thank you for your time and attention. I would be happy to answer any questions you may have and to make myself available for questions at the work session.
Thank you, Mr. Pilot. Questions from the committee? Seeing none, thanks for being here today. Hillary Moore, please. Unmute yourself and welcome.
All right. Senator Claxton, Representative Meyer, and members of the Health and Human Services Committee, my name is Hillary Moore and I live in Winslow. I am a single parent who has been actively participating in the HOPE program since January 2020. I am testifying today in support of LD 792. I am testifying in favor of this bill because the HOPE program has changed my life. In 2016, my 2-year-old daughter and I fled from Colorado with a one-way ticket and 2 suitcases. We had spent the past 2 years in and out of women's shelters for domestic violence. During this time, I was enrolled at the local university where I received a full ride in scholarships. When I returned to Maine, I transferred to an accredited online university to finish my bachelor's degree in social work. The transfer added on more time and less scholarships. Because of this, loans were utilized for both tuition and living costs. In 2018, after my son was born, my daughter's father passed away in Colorado and I took leave from school to be with her. My newborn son suffered breathing complications after birth and brought him in and out of NICU in Portland, and I was just at a loss. I was unsure if returning to school would be possible. My loans kept piling up, and I was a single mom of 2 children with medical complications. I didn't know if it was in me anymore to finish my degree. In the months leading up to January 2020, I was in touch with Sue Hamlet from Maine Equal Justice, who informed me I would be a perfect fit for a program called HOPE. I reached out to the HOPE program, and within a few days, my application was accepted, and I became one of the first members of the program. I was astonished by the various support systems HOPE had to offer, and finally found motivation to continue. I was blessed to have such an amazing support system behind me. Someone actually cared about me. HOPE has covered significant costs for my education. I was out of funds this year and about to withdraw from school when HOPE found me a $4,000 outside scholarship to get me to graduation, greatly minimizing my use of student loans and keeping me upright for a second time. HOPE financially assists with my son's daycare, vehicle registration, a portion of my textbooks and supplies, and even provided me a refurbished laptop. HOPE gives me the supports I need both financially and emotionally. With the help of HOPE, I am set to graduate with high honors in August. I was very lucky to have this opportunity with the HOPE program. Because I intend to do medical social work with my degree, I was accepted to HOPE through the healthcare category. Unfortunately, many other families could benefit from the HOPE program, but are outside the 3 categories of healthcare, engineering, or technology that are currently accepted. Maine also has a significant need for teachers during the pandemic, but they too are excluded from HOPE's accepted programs. Maine needs workers for many things, and people are pursuing programs that meet those needs. The HOPE program should be available to these people as well, so they can pave their own road to success. I almost gave up before HOPE came into my life, but with the help of this program, I was able to turn my life around and set an example for my children. You can achieve anything with perseverance, but sometimes we all just need a little help. Thank you for your time.
Thank you for your testimony, for being here today. Inspirational. Questions for Ms. Moore from the committee? Yes, Representative Zager.
Thank you, Madam Chair. I just wanted to thank Senator Claxton for bringing this forward. Thank Ms. Moore for your testimony. I'm so glad that you didn't give up hope, and I really believe that as a medical social worker, you will extend opportunities to other people. So thank you.
Thank you.
Any other questions? Yes, Representative Madigan.
Thank you, Madam Chair. I just want to thank Hillary for being today and welcome to the social work field.
Thank you. I appreciate it.
Up next is the Humane Systems, Samantha Warren. Welcome, Ms. Warren.
Good morning. How are you? That is a very tough act to follow, but I don't think ditto what she said is probably adequate testimony, but I would say that if I could. But thank you, Senator Claxton, Representative Mayer, and distinguished members of the committee. I am Sam Warren. I'm Director of Government and Community Relations for the University of Maine System, and we are here today in support of LD 792. As Hillary's story really illustrates, the HOPE program is a critical opportunity for low-income parenting students to transform their lives through the proven power of post-secondary education. And the mission of the program has certainly been made all the more important by the COVID pandemic. As you well know, those who are less educated have suffered more over the past year. And as we look ahead to a post-pandemic economy, the Federal Bureau of Labor Statistics projects the greatest employment growth will be in occupations that require a 4-year or graduate degree, with opening for occupations that demand advanced degrees increasing by more than double the rate of those requiring only an associate's or some college. The University of Maine System was very proud to be among a very diverse coalition that successfully advocated for the establishment of this program in the 128th legislature. Now we are honored to enroll a number of program participants at our universities, and we also oversee administration of the vital navigation support services provided to HOPE learners like Hillary by the Maine Educational Opportunity Center for which the University of Maine is the fiscal agent. We support allowing HOPE participants to pursue a wider range of four-year degree programs than those currently allowed. At a minimum, as you've heard, this would include four-year education degree program for which there is a huge demand for graduates. As you likely know, according to the Maine Department of Education, there are state teacher shortages in more than a dozen federally defined areas, including those that are of great importance to this committee and to our state, like early childhood, early elementary education, and teachers of students with disabilities. Because the minimum requirement to be hired by K through 12 schools, public schools in Maine for these positions is typically a four-year degree, these meaningful career paths are not currently available for HOPE participants. That said, we would urge the committee to go even further than this bill proposes and remove all restrictions related to four-year degree programs, provided they are industry recognized. And I think you'll hear a friendly amendment from Maine Equal Justice to that effect. This would appropriately acknowledge that stable employment in many good paying jobs in Maine requires at least a four-year degree, and that HOPE participants aspire to and are certainly capable of earning these door opening degrees. In fact, it is a four-year institution, the University of Maine at Augusta, that proudly enrolls the greatest number of HOPE participants. And in the HOPE program's first year, several dozen otherwise qualified individuals have been turned away because they wish to pursue a marketable bachelor's degree for a major not currently allowed, like criminal justice, or as you heard, social work. The vision of this, I'll wrap up. Yeah, the vision of this program was to provide post-secondary education and a pathway from poverty to prosperity for Maine people. We should not limit the potential of program participants or the success of Maine's economy and communities. We urge you to make the changes we've recommended here and look forward to serving more Mainers when you do.
Thank you. Questions from the committee for Ms. Warren? Seeing none, we appreciate you being here today. Last up is Mariah Gear. Ms. Gear.
Good morning, everyone. Thank you so much. So good morning, Senator Claxton, Representative Meyer, and members of the Health and Human Services Committee. My name is Mariah Gear, and I am the Moxie case coach at Maine Equal Justice. In my role at Maine Equal Justice, I work directly one-on-one with people who are trying to navigate public benefit programs like the HOPE program. I'm testifying in support of this bill today, both as someone who went to college myself as a low-income parent and as someone who now works to help others navigate public benefit programs. I know firsthand the struggles that come with navigating higher education as a parent. When my children were very young, I became a single mother, and then shortly after, we became homeless. I had to make decisions about how I would move forward and create a more stable life for us, and I chose to pursue a bachelor's degree. Looking back, I'm very grateful that my family qualified for TANF, as I had more flexibility in my choices at that time about what courses to pursue than I would have had under a program like the current rules of the HOPE program. The Parents as Scholars program through TANF provided me with much of the same assistance that I needed to be successful. And I knew many other parents at the time who weren't eligible for the same kind of support that I was relying on. Many of them were not able to complete their educational journeys. In 2016, I graduated with bachelor's degrees in psychology and anthropology, programs that are not included in the current HOPE rules. I will always be grateful for the opportunity that I was given to achieve my dream of earning a college degree, and I now get to use my education and my experiences to help others. I wouldn't be able to do the work that I do today were it not for the support that I received from Parents as Scholars. The HOPE program is wonderful, and I've been thrilled to watch its success and growth as it's launched over the past year. The same supports that I relied on to be successful as a low-income parent going to school are covered by HOPE, and then more. In my role at Maine Equal Justice, I talk to people all the time who are struggling to make ends meet, and I often hear from them that they would love to train to pursue a different career, but they can't go to school because of unmet needs like childcare and transportation. I'm thrilled when I get the chance to tell my clients about the HOPE programs, but too often I have to catch myself before giving them false hope. What do you want to go to school for? I have to ask. There is a state program that might help you, but it's really limited on the types of degree programs that it covers. Too often I wind up wishing that I hadn't brought it up in the first place because their dreams don't fit into their boxes currently covered by the HOPE program. There are many industries in Maine that have long been in need of trained workers. We often talk about ways to keep young people in the state, to attract people to move to our state, but what about making the most of the potential workforce that is already here? Educating parents allows them to fill those workforce needs while also achieving the goal of lowering child poverty in our state. The HOPE program pushes us closer to that goal, but it could be doing more.
30
We were
seconds.
very, all right, great. The only thing I want to add is that Maine Equal Justice does have an amendment that we would love to see added to this bill, in that when Tony talked about the Department of Labor's Center for Workforce Research and Information database, there's a separate database that's part of the Center for Workforce Research and Information that's just slightly different. It maintains a high wage and in-demand jobs by education database. We would like for the bill to use this database instead when it comes to approvable job lists. This has in-demand jobs. They're high wage jobs, so it makes sure that the people are going into jobs that they're going to be earning a contemporary wage. This will be more likely to keep them stable. And it looks at jobs that have an outlook of at least 20 jobs instead of at least 30 jobs. We think this is a better choice. I'm including a draft of that amendment in this testimony. Also, I just want to make sure that you know that the department will also retain the discretion to approve or disapprove occupations that are not on this list if people are able to make the argument that they should be included. So thank you for the opportunity to express your support. I'm happy to answer any questions that you might have.
Thank you. Questions from Ms. Gear? Seeing none, thank you for sharing your story and for the work you do. We look forward to seeing you and the amendment at the work session. Oh, I'm sorry. Representative Perry does have a question. You have to unmute yourself, Ann.
Sorry.
Happens to all of us.
It does.
Yes, twice today. I got to remember this. No, I was looking up the education and jobs listing that you brought forward, which was very interesting because it had a number of jobs that really work for a training program as compared to a 4-year and also high paying. So I was glad to see that. I think it does open things up. And thank you for bringing that forward.
Thank you. It's a great list because it can be sorted. So if somebody wants to do a 4-year program, they can actually sort it and look at what those are that would need a 4-year program as well. So it's easier to navigate as far as like, what should I actually look into? It's a really great database.
Thank you. Seeing no other questions. And no one else here to testify on 792. We do have a full agenda of public hearings for the afternoon. Actually, we'll go back and ask the committee if there are any requests for additional information on 792 for Ms. Dooling. Seeing none. So I would suggest that we take a bit of a break for lunch before we get back into a busy afternoon of public hearings. It's 10 minutes to noon. Should we reconvene at 12:30? Senator Claxton?
That sounds fine to me.
Okay, so we will return this afternoon for the rest of our public hearings. They are in this order. I don't think we've had any change in the order that's listed. It will be LD 376 followed by 784, 799, 822, 910, 1064, and finally 1069. So we will see you at 12:30 this afternoon.
Very good.
I want to thank the chairs for that lunch break.
Blame that on Representative Meyer. That was welcome. Hopefully this afternoon won't be quite as interesting. One, two, three, four, five, 6, 7. So that gets us back to a quorum and allows us to resume the public hearing portion of today's Committee on Health and Human Services. We'll be hearing a total of 8 bills this afternoon, 6 or 8, 7 or 8. And we'll start with LD 376. And I understand Senator Lawrence is with us to do the introductions. So if we can get Senator Lawrence in the room, welcome, sir. If you'd like to unmute yourself and join us, we'd be
Thank you, Senator Claxton.
grateful to hear from you.
I'm sorry, were you going to do introductions of the committee first, or are you jumping right in the bill?
Just jumping right in.
You guys are so efficient. It takes us maybe on EUT, maybe 20 minutes to introduce ourselves before we get into things. Thank you very much, Senator Claxton, Representative Meyer. I'm working off 3 screens here today, so I'm not ignoring you. And honorable members of the Health and Human Services Committee, I am Senator Mark Lawrence. I represent Southern York County, and I'm very proud to have Representative Meyer as my representative. I represent the towns of Elliott, Kittery, York, Ogunquit, South Berwick, and part of Berwick. And I'm here today to introduce LD 376, resolved to increase chiropractic reimbursement rates under the Main Care Program. This legislation that veteran committee members may be, this is legislation that veteran committee members may be familiar with. It passed in the committee in the 128th and 129th legislatures. Unfortunately, it was not funded at that time. Doctors of chiropractic have not had an increase under Main Care in 21 years, which actually pretty much dates back to when I used to be in the legislature previously. That's 21 years of stagnant reimbursement at a time when Main Care patients' need for non-drug chiropractic care has only increased. This legislation increases reimbursement to 70% of Medicare, which has been the standard, often used as a fair level of reimbursement. I ask that you pass this legislation once again and help make sure that chiropractic care remains an important part of the Main Care system. And just as a side note off my written testimony, when I served in the House 4 years ago, I chaired what is now the Health Coverage, Insurance, and Financial Institutions Committee. And one of the things we constantly realized is alternative care, like chiropractic, that's non-drug related, that's focuses in on the wellness of the patient, can go a long way towards reducing overall healthcare costs in our system. With that, I'd be happy to answer any questions from the distinguished members of the committee. I will note in my, I think it's about 18 years of service, I have never served on Health and Human Services, so therefore I am not going to be sending you any virtual cookies at this point.
Thank you, sir, for introducing this bill. Are there any questions for Senator Lawrence? I don't see any. Thank you again for being here. Have a good day.
Thank you. You too.
Next, we'll hear from Andre Nato. If you would unmute yourself and join us. And then we'll hear from Daniel Mirowitz and John Royce.
Okay, I believe I have unmuted myself. Can you hear me?
That worked.
Perfect. Okay, good afternoon. My name is Andre Neto, and I am a practicing chiropractor in Augusta, Maine. I've been practicing in Maine for 30 years, and I am a past president of the Maine Chiropractic Association. I am testifying in support of LD 376. This is an increase for reimbursement for the chiropractic manipulation services. Most healthcare professions have received cost of living increases over the last several years, but not the doctor of chiropractic. The last bill that passed to increase payment from MaineCare for doctors of chiropractic passed in 1998 and was funded in 2000. That's over 20 years ago. The chiropractic profession has been a mainstay in healthcare for several decades. It has been a very effective and proven means of helping patients manage pain and maintain activities of daily living. The chiropractic profession has also been very active in decreasing the need for opioid medication by helping patients manage their own pain and improve their function. Over the last year with the pandemic, the chiropractic profession mostly stayed open, active, and involved in healthcare. Patients with acute low back pain that would typically go to the emergency room for treatment sought care from the chiropractic doctors. Since there was such a demand on the ER departments, the chiropractic profession's effectiveness in treating acute low back pain served Maine to help decrease the burden that was being placed on the hospitals and the emergency rooms by this pandemic. This bill is not something special for chiropractors. Show me any profession or occupation that has not received a cost of living increase on a somewhat regular basis. We do provide a service that is much needed in the state of Maine, and it helps our patients considerably. Finally, increasing compensation would also encourage more doctors of chiropractic to enroll in the Medicare system and treat Maine residents or Maine.
3 seconds, Dr. Nato.
Yes. Okay, I'm sorry. Okay, let's see. Increasing compensation would encourage more doctors of chiropractic to be involved with the Maine care system. There is a shortage of healthcare providers in the state, and increasing the numbers of chiropractic would help take the burden off of many of those providers. Thank you for your time and your consideration.
Thank you for your testimony, Dr. Neto. Are there any questions for the good doctor? I don't see any. So we'll move, thank you for being here, and we'll move on to Daniel Mirowitz.
Thank you, Senator Claxton, Representative Meyer, and esteemed members of the Joint Standing Committee on Health and Human Services. My name is Dr. Daniel Meyerowitz. I'm a resident of Holden, just outside of Bangor, and a lifelong resident of the state of Maine. I'm a third-generation chiropractor. I'm in my 12th year of practice, and I'm the current president of the Maine Chiropractic Association. I'll be testifying on behalf of my patients in favor of this bill, which, as you heard, was passed by the 128th and 129th legislatures before being left unfunded due to other priorities by the appropriations table. Few can deny there's a growing shortage of healthcare providers in the state of Maine. The vast majority of the state qualifies as being federally underserved. There are over 300 currently licensed chiropractors in the state of Maine, all with the training and ability to diagnose and treat a tremendous variety of physical and musculoskeletal conditions, all without drugs and surgery. Some say our population is underserved. I say chiropractic is underutilized. I've spoken with many of my colleagues about the Maine Care program, and the majority of them would tell me, and we've done this with some of our internal sampling of our association, that they would be interested in joining as a provider, but cannot do so because the reimbursement rates are simply too low. It is untenable to run a practice with a high population in the Maine Care program at the current reimbursement rates. Without a much needed and now twice approved but unfunded increase in reimbursement, I find this unlikely to change. Without a reimbursement increase, hundreds of portal of entry trained doctorate level providers will continue to sit on the sidelines, their services unavailable to your constituents solely because of legislated economics. For those concerned about cost, chiropractic has proven to be a significantly lower cost than walk-in care facilities or emergency departments, and again, without the need for any drugs or surgeries. I'd like to speak as a provider in a relatively rural part of the state. I'm about 10 minutes east of Bangor, which doesn't sound rural, but believe it or not, there is an absolute absence of chiropractors east of Ellsworth. So I get a tremendously high population of main care east of Ellsworth, even people from Machias and Lubec that come to visit me, which is 60 to 70 miles round trip. And that, after some digging, brought up a really interesting thought in terms of cost of such legislation. When a doctor retires and there's no one coming in to take over their practice, which has happened in the northern and eastern parts of our state, people have to travel somewhere for services. So again, 2 hours round trip for an appointment is pretty outrageous. But one thing I found out about the main care program is that they reimburse for travel up to, I believe, 51 cents per mile. So our legislated reimbursement rate for main care is about $19.40 for the primary service that we do. It takes 48 miles round trip of driving to yield a higher reimbursement to the member than to the provider. So one of the things I think, thank you, that has been missed is that we're paying significant amounts higher in claims out in terms of travel than if we just encouraged more doctors to be part of the program in the more rural parts of our state. At what you might hear some today is 70% is the baseline, what we look for a goal for main care reimbursement out of Medicare coverage. And if you look at the global amount of chiropractic codes, we're close to 70%. But the problem with that is that includes all of the X-ray codes that we're eligible to perform, but very rarely do. So when you look at the vast majority of the services we perform, it's about a 50-50 split from just 2 codes that both reimburse the same amount. And the second code is the one we're having the biggest problem with. That rates about 50% of the Medicare amount. And that's what has prompted our bill now 3 times to come in front of committee to try to make this program more economical for chiropractors to get more providers into our underserved areas of the state. So passing this bill will give you really 2 immediate benefits: incentivizing my colleagues to participate in the main care program, which will provide a whole bunch of extra providers in for your constituents. And indirectly, it will help address the opiate crisis because we are a low-cost, drug-free, surgery-free provider that cannot prescribe an opiate to a low back pain patient. It is impossible for a low back pain patient to become addicted to opiates seeing a chiropractor. LD 376 is long overdue. It is a very minimal overall change. I believe the state general fund is $76,000 expenditures in the first year, and a much larger system that really could stand to yield tremendous benefits. Thank you. I'm open to any questions.
Thank you, Dr. Mirowitz. Are there any questions for the doctor? I don't see any. Thank you for taking time to testify.
Thank you.
And now we'll hear from John Royce. When you unmute yourself. Now we can hear you. Nope. No, we still can't hear you, sir.
How about now? Okay.
That's better.
Senator, whoop. Now?
Now is okay.
Okay. That must be a problem. Senator Claxton, Representative Meyer, members of the Health and Human Services Committee. You got that reverb? Yeah.
We're okay.
Okay. Okay. My name is John Royce. I'm here representing the Maine Chiropractic Association. I've supported this legislation over the last 2 regular sessions of the legislature, where it passed this committee and went on to the appropriations table twice. Doctors of chiropractic have been treating Medicare patients for 21 years without an increase in reimbursement, and that's a very long stretch of time. Clearly, the amount of time without an increase makes it difficult for doctors of chiropractic to continue within the main care program. Doctors of chiropractic are competing in the healthcare marketplace with a host of other providers and they do so with some of the lowest costs and highest patient satisfaction in the system. Doctors of chiropractic treat patients without the use of drugs, and given our current problems in that area, it is more important than ever to keep doctors of chiropractic in the main care system. We ask for your support of LD 376. I will be attending the work session, and I have submitted written testimony. Thank you. I'd be happy to answer any questions.
Thank you. Thank you, Mr. Royce. Any questions for Mr. Royce? I don't see any. We'll look for you at the work session, and we'll move now to Robert Reed.
Thank you. Good afternoon. To the chair, Senator Claxton, members of the committee, thanks for allowing my testimony today. My name is Robert Reed. I am the executive director of the Maine Chiropractic Association. My testimony today is in support of the bill before you, and I'd like to concentrate on the history of what got us to this place. Back in August of 2010, there was emergency legislation passed to allow additional reimbursement for a specific group of healthcare providers, basically those in primary care, to bring them up to 70%. They were at similar failing rates to what we see now for chiropractic. Unfortunately, Maine Care can't set reimbursement rates by provider type in the manner that was requested. So at some point in September, Maine Care just simply increased all the rates regardless of provider type. At the same time, on September 10th, they carved out chiropractic, optometry, and podiatry to their own fee schedules and did not improve those rates. So while everyone got a bump, we didn't see it for the codes we use the most. Those codes now we're getting 45 to 47% of that in Medicare allowed, where other people are getting 67, 68% because of cost of inflation. So the codes we use the most, we're at 45% of, really need your assistance. Again, we've brought this before you twice. We understand it wasn't able to be funded in the past, even though this committee did approve the request, and we ask you to consider that again. I have surveyed our providers. We have 2/3 of all chiropractors in Maine now currently accept Maine Care. I think that's pretty close to what other portions of the healthcare industry would do. And we've talked to those who do not, and about 75% of those who do not have indicated they would consider being open to Maine Care patients if the reimbursement was better. I understand you have also seen the rate studies. I participated in those rate studies and did point out some significant flaws in the rate studies. Again, because each service type is rated equally, they don't look at the services by the volume of times you do that code. So a chiropractor might see a patient once for a new patient exam, but might see them 12 times for manipulative treatment. But those two codes are equally weighted. One of them we're pretty close to okay on, but the manipulation we get shorted. So that rate study, as I brought up during my testimony there, has some pretty big flaws, although it does bring us to, I understand, the top 7 groups of healthcare providers that should be done first. I understand thank you. I understand Maine Care is going to make a request to you to not approve any of these rate increases this year. I would ask that you please consider our rate increase, and if not in full, if we could begin some kind of discussion on a step system to start getting us to where we need to be. Again, I'm happy to answer your questions, and thank you for allowing me my testimony.
Thank you, Mr. Reed. I don't see any questions from the group. Thank you again for being here. So I don't see anybody else who's here to testify for. And I don't see anybody who wishes to testify against, and neither for nor against. So that will conclude the public hearing portion of our consideration of LD 376. Are there any questions we'd like to direct to our analyst? Yes, Representative Zager.
Mr. Chair, I think that the promise of this bill, is that we can expand coverage expand the availability of this non-drug, non-surgical approach. It occurs to me that the fiscal note, though, since it's not dynamic, does not account for that. So I was wondering if Luke or somebody else who could provide insight as to if 75% of the remaining chiropractors who don't currently take main care do open their practices, which I think is what we would like to see happen. What would be an estimate of what the fiscal note might be? I recognize that we can't do a dynamic fiscal note, but just some sort of insights into what the actual costs to main care might be if the full promise of this legislation were achieved.
Okay. I see Ms. Fromm-Bisley taking notes. I don't see any other questions. All right. So before we begin consideration of LD 784, why don't we go around the horn and introduce ourselves? We didn't want to hold up Senator Lawrence when he showed up, so we can do that now. Starting with Representative Zager.
Thank you, Mr. Chair. Sam Zager, District 41, Portland. Good afternoon to everyone.
Representative Lemelin.
Good afternoon, everyone. My name is Michael Lemlin. I represent House District 88, Chelsea, Jefferson, Whitefield, and half of Noblesboro.
Representative Perry. When you unmute yourself, we'll come back to Representative Perry and go to Representative Griffin.
Good afternoon. My name is Abigail Griffin. I represent House District 102, which is Glenburn, Levant, and Candace.
Representative Craven.
Thank you, Mr. Chair. I'm Margaret Craven, and I represent House District 59, which is part of Lewiston.
And Senator Moore.
Good afternoon. My name is Mary Ann Moore, and I represent Senate District 6, which is all of Washington County, as well as Goldsboro, Winter Harbor, and Sullivan in Hancock County as well.
Representative Meyer.
Thank you, Mr. Chair. I am Representative Michelle Meyer, proudly serving Southern Maine's House District 2, which is all of Elliott and parts of Kittery and South Berwick.
Representative Stover has joined us.
Good afternoon. My name is Holly Stover. I represent House District 89.
And I'm Ned Claxton. I represent Senate District 20, which consists of Auburn, Minot, Mechanic Falls, Poland, and New Gloucester. We're also joined by Representative Perry.
Yes, good afternoon. I'm Representative Ann Perry. I represent House District 140, which includes Indian Township, Baileyville, Bering, Calais, Charlotte, Robbinston, Perry, Pembroke, and Pleasant Point.
Very good. So now we'll move to consideration of LD 784. Thank you for being here, Senator Lawrence. You can have the rest of the afternoon off.
Thank you very much, Chair. I stayed on because I like to meet the committee members. You know, not being in Augusta, I don't see many of the new faces, so it's nice to meet you all.
Okay, so LD 784 is to be presented by Representative Craven, I believe.
Thank you, Mr. Chair. Good afternoon, Senator Claxton, Representative Meyer, and fellow members of the Health and Human Services Committee. My name is Margaret Craven, and I represent House District part of Lewiston. I'm pleased to be with you today to introduce LD 784, an act to amend the law governing approval authority over oversight of certified nursing assistant education programs. The bill before you today is the result of conversations with nursing homes and other healthcare stakeholders regarding the supply pool of certified nursing assistants, CNAs, not keeping up with growing demand. We knew there was a shortage of CNAs before the COVID pandemic, but this shortage has only worsened over the course of last year. In a WAGM news story earlier this year, a nurse at Cary Medical Center in Caribou said, right now in healthcare, it's very difficult to combine CNAs and healthcare professionals on both long-term care settings and the hospital settings. There's definitely a shortage and a need for CNAs. And in February, Maine Healthcare Association President Rick Erb told WGME that it is no question that we are facing a severe shortage in all positions, but particularly CNAs. COVID-19 has definitely made it a tough situation harder. Current law requires that any healthcare facility interested in carrying out their own training program for CNAs must first demonstrate that an educational institution is unable to provide such a program. This means that rather than allow for several programs to be carried out in a particular region of the state simultaneously, healthcare facilities must defer to educational institutions. This is a disservice to Mainers looking to enter this healthcare profession. It's also a disservice to our families and neighbors who are going to the hospital or entering long-term care facilities to find that the facility is understaffed. If this bill becomes law, healthcare settings will be able to train CNAs in-house. These in-house programs would still need to secure approval from the Department of Health and Human Services, consistent with the curriculum approved by the State Board of Nursing, and also fulfill all standards established by both the department and the board. In closing, this bill simplifies the requirements of healthcare facilities to carry out their own CNA training programs, and it's one step we can take to address the shortage of CNAs in Maine. And thank you for your time and consideration. And there will be people coming after me who can definitely attest to this need better than I can. So if you want to ask me questions, you can, but probably better wait.
Okay, thank you for that, Representative Craven. That will take us to April Nichols. If you are welcome, the floor is yours.
Thank you. Good afternoon, Senator Claxton and Representative Mayer, the members of the committee. My name is April Nichols, and I'm the Regional Vice President of Operations for the 11 Genesis Centers in Maine. The centers are located from Kennebunk to Orono. And I'm here today to ask for your support with the amendment of the law governing approval authority over the oversight of certified nursing aid assistant education programs. The long-term care industry in Maine is in the midst of a nursing staffing crisis. As a company, we strive to have ongoing classes for CNAs in our 11 centers. We employ 3 full-time RNs to educate and train CNAs. The barriers and the differences between the adult ed programs often cause delays in expediting these crucial classes. The adult ed requirements for participation vary throughout the state, and some have stated they cannot provide assistance and involvement. And when that occurs, we apply independently to get these classes approved. Some adult ed programs want to approve our instructors or approve our classrooms, and this causes time delays. Some want to provide CASA pre-testing, and others want us to do that. These inconsistencies make it confusing to keep classes available and flowing throughout the state. Please amend this law and remove the requirement that healthcare facilities must seek approval and have affiliation with an adult education program, or provide written statement that the education program cannot provide that training within 30 days. Long-term care cannot afford delays in onboarding CNAs. As you know, direct caregivers are essential to our ability to provide quality care, and we need them now more than ever. I'd like to take a moment to thank Representative Craven, who I have worked with at the Center Marshwood in Lewiston. Thank you for sponsoring this bill. Does anyone have any questions that they'd like to ask me?
Thank you, Ms. Nichols. Are there any questions? So yeah, I have one. Can you tell me roughly how many people you hire from formal school education and how many from job site training for CNA work?
Quite honestly, Mr. Claxton, we're hiring every CNA that we can get through our doors.
Okay.
And there's not enough. We still have extremely high numbers of agency staffing in our buildings.
Okay. Which is an expensive way to go. Yeah.
Very expensive.
Okay. Well, thank you. Okay. I don't see any questions. So again, thank you for being here. And now we'll ask Beth Boutot to unmute herself and contribute her testimony.
Can you hear me?
We can.
Well, thank you for taking the time this afternoon to consider this bill. Good afternoon to Senator Claxton, Representative Meyer, and members of the committee. I'm Beth Boutot. I'm a nurse educator and CNA instructor for First Atlantic Healthcare. Our company provides nursing home and assisted living services in 18 facilities across Maine. And I'm pleased to testify in support of LD 784 today and thank Representative Craven for sponsoring it. First Atlantic Healthcare's state-approved certified nursing assistant programs meet all of the Maine State Board of Nursing and DHHS requirements for both traditional and online classroom courses. We are dedicated to high-quality learning with a focus on real-world preparation for the participants who will be our employees. We currently operate company-standardized CNA classes overseen by 3 separate educational entities. Each one has their own administrative idiosyncrasies, as you've heard. The ability to manage all aspects of the training program internally without adult education oversight would create a more efficient process within our system and would not hinder our ability to generate qualified nursing assistants. The current requirement for educational partner also creates some fiscal waste. Most of the tasks needed to start a new class and submit annual program renewal documentation are being done by our program instructors. These documents are then submitted to our education partner, and then they submit the documents to the state on our behalf. Classroom teachers, locations, RN clinical instructors, training supplies, clinical sites, and determination of student competency are all provided by the healthcare company instructors, not our educational entities. All this is done by the healthcare company. However, we still pay a per student administrative fee to our education partners. Eliminating the duplication will help lower the associated costs of training new CNAs. The nature of nursing facilities is that we require staffing 365 days a year, 24 hours a day. Nursing facility training programs have the ability to schedule classes and clinical training according to their own needs as often as necessary. However, the current arrangement creates hardships when facility programs must structure class start and stop dates around the education program schedule rather than our staffing needs. We have a really good working relationship with our education partners. Their administrative oversight, however, is unnecessary and does not affect the quality of our program. All administrative tasks, including ordering and proctoring state exams, can be effectively managed by a facility training program in a timely, efficient, and cost-effective manner without the oversight of an adult ed partner. This forced arrangement has no bearing on our ability to graduate well-prepared nursing assistants. Thank you for the opportunity to present this position, and I hope you will support LD 784.
Thank you, Ms. Boutot. Are there any questions for her? So you'd still need to get approval for a program, or still need to, from the Department of Health and Human Services.
Correct.
You just like to avoid having to do the dance with an educational entity that complicates things.
Absolutely. It tends not to be 30 days, it tends to be 2 weeks. They take a 2-week vacation in the summer. They take a 2-week vacation at Christmas time. And it doesn't meet the standard of not being able to start a class within 30 days.
Okay.
They're wonderful, but we could do it better and faster.
With greater flexibility. Okay.
Absolutely.
Thank you, Mr. Boutot, for your testimony. I don't see any questions. So now we'll go to Mr. Erb. Welcome back.
Good to be back. Good afternoon, Senator Claxton, Representative Meyer, and members of the committee. My name is Rick Erb. I'm the president and CEO of Maine Healthcare Association. We represent the nursing homes and assisted living facilities. Here to testify in support of LD 784 and thank Representative Craven for sponsoring it. This bill proposes a minor change in the timing of CNA training that could have a big impact on increasing the number of certified staff in long-term care facilities. Under current law, healthcare facilities may ask approval from DHHS to provide CNA training on site if they can demonstrate that an educational institution cannot also provide such a program within 30 days of the application. LD 784 would eliminate this administrative burden of proving there is no educational alternative and allow healthcare facilities to apply to provide the training as soon as possible when they have the application, when they have applicants. Healthcare facilities must utilize the Board of Nursing approved CNA curriculum and meet all DHHS application requirements. This bill does not change those obligations. The ability of educational institutions to provide this training varies across the state. Historically, adult education programs have provided many of these courses working in concert with their local healthcare providers. In many cases, these arrangements meet the needs of all parties involved. In other instances, and what is really the driver of this bill is that there are times when facilities are unable to secure training when they have students ready and eager to begin their career in long-term care. For example, an adult education program might need, say, 10 enrolled students for a course to be economically feasible. The local facility may have 5 students and meet all DHHS and Board of Nursing requirements to provide the course. In this scenario, they must wait until the educational entity determines that they can hold the course within 30 days. Once the facility has proven that there is not an alternative training partner within 30 days, DHHS approval often takes even longer. It seems unreasonable to ask students to potentially wait 30 or more days for education if a healthcare facility who meets all of the standards can provide the opportunity almost immediately. The provision have been in place for many years and may have
30
once
seconds, Mr. Erb.
Thank you. May once have served a purpose, but in today's staffing environment, it seems archaic, detrimental, and unresponsive to long-term care workforce needs. I asked my fellow state associations whether they have similar restrictions, and 16 responded, none of them have those restrictions. So in closing, I will ask you to support LD 784. I'm happy to speak further about the demand for CNAs and any other questions you may have. Thank you.
Are there any questions for Mr. Erb? Thank you for your testimony. I don't see any. I do have a couple though. How many of our nursing facilities have all the CNAs they need without travelers or agency?
Without agent, you know, we have a handful, I would say, that have been able to avoid agency utilization, but there aren't as many in that position as there used to be. The majority of them do require agency staffing. Even coming into this year, I've seen statistics that show that Maine is the highest utilizer of agency staffing in long-term care. I would attribute that to the low number of younger people in the state of Maine, the high staffing levels in our facilities, and the just general greater need for long-term care services in such an aging state.
At this point, we haven't received any negative or against testimony. What are we likely to hear back as pushback from the educational institutions?
Well, no one has communicated with me on that. I honestly don't know.
Okay.
Yeah, the other thing, I'm not familiar with why the regulation began. I really do not know. I don't know if it was a different era. I do not know why.
Okay. Representative Craven, you had your hand up.
Yes, thank you. I did hear from the community colleges. They had some questions initially, but after we talked about what the process was and what the Maine Health Association were looking for, they were satisfied. So they weren't going to be testifying either for or against, or, so.
Thank you for that information. All right. I don't see any other questions, so thank you, Mr. Erb.
Thank you.
That lets us go on to Ms. Hayden. Welcome.
Hi, good afternoon, Senator Claxton, Representative Meyer, and members of the committee. My name is Shelley Hayden, and I'm the Director of Clinical Operations for Continuum Health Services. Our company provides nursing home and assisted living services in facilities from Auburn to Kittery. I'm pleased today to testify in support of LD 784 and thank Representative Craven for sponsoring this. Continuum Health Services appreciates all adult education offers for educational resources and supports to Maine communities, and we value our working relationship with them now and going forward. But I am in favor of removing any barriers or delays for facilities providing CNA programs irrespective of adult education involvement. Long-term care staffing shortages are really reaching critical proportions, and any hoop, small or large, that can be safely removed, allowing nursing facilities to quickly get educational opportunities off the ground should be considered. We've long provided our own CNA classroom and clinical instructors at our own cost, over $400,000 in the last about 4.5 years. In addition, we pay a fee to adult ed for each class that's held, which primarily includes, in our experience, them administering a reading exam called the CASAs to each student prior to the class, and then proctoring the final state examination. We have paid over $43,000 in fees in the last 5 years to our adult education partners. We've discovered during the pandemic and adult education's absence that we could be trusted to successfully provide both the CASAS reading exam and proctor the final state examination. We do our own advertising, interviewing, student selection for all of our classes currently. Adult ed has had little to no involvement depending on the community. And while their involvement is always welcome, it's not necessary for the process. Facilities also provide adult education with instructor resumes, course outlines, and other information that in turn just gets submitted for course approval. And that can easily be done by the facilities themselves. The added burdens of cost and coordination with adult education are unnecessary to administer a successful CNA class. There isn't any reason that I can think of that these areas can't be formally placed in the hands of long-term care facilities. Thank you for your time and welcome any questions.
Are there any questions for Ms. Hayden? I don't see any. Representative Meyer.
Thank you, Mr. Chair. The contacts at several of the adult ed programs here in Southern Maine have told me over the last few years they have a hard time filling the position of nurse educator in their programs. Mm-hmm. I'm assuming that's still a problem and can also cause a delay in training.
That absolutely is still a problem. And for probably 6 years now, this company has just hired at our own expense educators. 4 years ago, when I came to the position, I realized just how significant the staffing shortage was becoming and actually added 2 more educators, per diem educators. And because really we're in a position, all of us in long-term care, of staff creation. We have recycled every possible CNA there is available in the community, and it really is about creating your own staff now. And so we've put resources toward that and have had several classes. Really, as I said before, the only thing adult ed provides to our company at this point is administering an exam and coming into our building and proctoring the state final exam. And during the pandemic, they haven't even provided those services yet. We continue to pay fees. So it's really become unnecessary over time.
Thank you.
You're welcome.
Thank you, Ms. Hayden. I don't see any other questions. I think that concludes the 4 testimony related to LD 784. I don't see anybody who's opposed, and I don't see anybody who's neither for nor against. So that'll conclude the public hearing portion of our consideration of LD 799. I note that Senator Baldacci has joined us, and would you take a moment to introduce yourself, sir?
Thank you, Senator Claxton. My name is Joe Baldacci. I represent Senate District 9, which is the city of Bangor and the town of Herman. Thank you.
Thank you. And at this point, we can proceed to consideration of LD 799. And as I understand it, Senator Moore will be doing that introduction.
Thank you, Senator Claxton. I appreciate the opportunity to do that. Good afternoon, Senator Claxton, Representative Meyer, and my fellow members of the Joint Standing Committee on Health and Human Services. As you know, my name is Mary Ann Moore, and I represent Senate District 6, which includes all of Washington County, along with the Winter Harbor, Goldsboro, and Sullivan and Hancock County. I am here today to present LD 799, an act to amend the procedures for veterinarians in the Controlled Substances Prescription Monitoring Program. In 2018, this committee passed LD 1730, which removed veterinarians from the Controlled Substances Prescription Monitoring Program, or PMP. Although LD 1730 did retain aspects of the PMP that veterinarians must take part in, the legislation provided a waiver for veterinarians from prescribing certain medications electronically. At that time, there was no electronic platform for prescribing that was widely available for veterinarians. As you can imagine, with veterinarians in practices large and small, along with those who are almost fully mobile, an electronic platform that is widely adopted is difficult to produce. The waiver set forth in 2018 is set to expire in July 2022, and there is still no available software for veterinarians to electronically prescribe controlled substances. LD 79 simply delays the requirement further until 2025. Hopefully by that time, a platform will be available. Veterinarians dispense significantly fewer opiates and benzodiazepines, I never can pronounce that word.
Benzodiazepines.
Thank you, Dr. Claxton. Than they did in 2018. The normal practice is to send prescriptions to pharmacies to be filled, and they in turn report that to the PMP program. Therefore, this bill would have little to no effect on the efficacies of the PMP program. I hope you will support our very busy veterinarians in the state and vote to support LD 799. With a shortage in Maine and the issues surrounding COVID-19, this profession is already facing a number of challenges. And I would be happy to answer any questions that I might be able to help answer.
Other than how to pronounce benzodiazepines.
Thank you.
Any questions of the senator? Thank you for introducing that. I understand that Senator Bennett was going to testify in support, but isn't quite available at this point. So we'll leave that slot open for him. And we'll ask Casey Cole to join us after you unmute and share your testimony.
Thank you. Good afternoon, Senator Claxton, Representative Meyer, and the rest of the Health and Human Services Committee. I'm Dr. Casey Cole. I'm the president of the Maine Veterinary Medical Association, and I'm here to testify in support of LD 799, an act to amend procedures for veterinarians in the Controlled Substances Prescription Monitoring Program. Veterinarians prescribe few controlled substances, but what few we do prescribe are essential. We prescribe them mostly to safely control pain in patients that recently underwent surgery, control seizures in epileptic patients, and as rescue drugs for owners to keep on hand if their pet has a cluster of seizures. These situations absolutely require controlled substances to be prescribed, but our ability to prescribe controlled substances will soon be limited without LD 799. The passing of LD 1730 in 2018 gave us veterinarians a temporary exemption from the requirement to prescribe controlled substances electronically. As we near the end of the exemption in July 2022, we will not have any e-prescription software that functions with veterinary practice software. Once the exemption expires, veterinarians will no longer be able to write any prescriptions for controlled substances and will instead have to rely on dispensing the substances from their own clinics. This will have a negative impact for veterinarians and pet owners throughout the state. One example, veterinarians in Maine are required to provide prescriptions to clients instead of dispensing drugs if the client requests prescription. After July 2022, we will no longer be able to fulfill this requirement for controlled substances. LD 1730 was an effective measure, and as far as I'm aware, the e-prescribing waiver did not cause any issues for the public. I asked the committee to vote to extend the existing e-prescribing waiver to ensure that veterinary community can maintain the ability to prescribe controlled substances until there is an e-prescribing software available to veterinarians. Thank you for your time. I'm happy to answer any questions.
Thank you for your testimony, Dr. Cole. Are there any questions for Dr. Cole? I have one in terms of how controlled substances are dispensed. How often does that come out of the office versus through a pharmacy?
It depends on the case. I actually work emergency, so the cases
Okay.
I do prescribe for tend to be out of office just for a couple days so they can get a prescription from a pharmacy. But other things like seizure patients that just need, some diazepam on hand in case they have a cluster, that usually is to a pharmacy. Or even major surgeries will be to a pharmacy.
Okay. And so you would give a relatively short period of time and a prescription if there was longer term therapy needed. The prescription would go to a pharmacy.
Mhm.
The shorter term one would be out of the office.
Yeah. Generally, myself, I just give 48 hours and have them recheck with their own practicing veterinarian, general practice vet. Yeah.
Okay. Okay. Thank you for that. Are there any other questions of Dr. Cole? Thank you for being here.
Thank you.
And we'll hear now from, I'm sorry, my vision is stinky. Soverell? I apologize. You can correct me when you unmute.
Hey, thank you, Chairman Claxton. It's Soverell. That was very close. And thank you, committee members. I want to take a moment to thank Senator Moore for sponsoring our bill. My name is Catherine Soverell. I'm Executive Director of the Maine Veterinary Medical Association. I have submitted testimony on behalf of the MVMA, which really echoes what Dr. Cole and Senator Moore have already said. So I'd like to just take this time to read Dr. Amanda Biesel's testimony, which I also submitted, and she asked me to read on her behalf. Just one moment. To Senator Claxton, Representative Meyer, and fellow members of the Joint Standing Committee on Health and Human Services, I am testifying in support of LD 799. This bill is to create an additional extension for a blanket e-prescribing waiver for veterinarians in the state of Maine for opioids and benzodiazepines under the Maine PMP law. Over the past 5 years since the original PMP bill that included veterinarians was passed, I have continued to work to determine if and how veterinarians could eventually come into compliance with the e-prescribing aspects of the bill. This has unfortunately remained a large hurdle. I've reached out to veterinary electronic medical record software companies who are either unable or unwilling to incorporate electronic prescribing to human pharmacies within the software. I do still hope that this may exist in the future, but it is not available now and not on the immediate horizon. In addition, I have continued to research available online options for e-prescribing that are targeted for human medicine. Online programs do exist now for non-controlled substances for free, but I have not found a reasonable option for controlled substances at this time. In addition, the MVMA has continued to work with the Maine PMP Advisory Council, and we hope that relationship would allow us to comply with e-prescribing if a feasible option is found by the department before the set date. Currently, veterinarians prescribe very few opioids or benzodiazepines to patients on a chronic basis. Note, the previous law change with LD 1730 in 2018 allowed veterinarians to dispense short 48-hour acute treatments without checking the PMP database. In general, veterinarians, including myself, will dispense this from our own pharmacies in our clinics. Many veterinarians, due to public health concerns and client privacy concerns with the PMP database, try to avoid dispensing chronic prescriptions in which we would need to report that dispensing into the system. Therefore, I personally prefer to give a physical prescription to the client to take to a pharmacy to fill the prescription, where the pharmacy can appropriately use the PMP database. In preparing this testimony, I did another search yesterday to determine if there are any new products on the market. I went so far as to download a free version. I attempted to create an account and cannot because it requires an NPI, National Provider Identifier, which veterinarians do not have and cannot acquire. Therefore, I cannot even attempt to purchase or use e-prescribing software at this time as it requires an NPI number. I do not know when veterinarians will be included in these programs or if our own EMRs will adapt. And because of this, we are requesting an extension of the blanket waiver. Thank you for your time, and we hope you will support LD 799. Sincerely, Dr. Amanda Beazle.
Thank you for
Thank
bringing
you.
Thank you for bringing that testimony. That answers a number of questions. Are there any questions that you'd like to direct to the witness? I don't see any. So again, thank you for being here. I don't
you.
see anybody else here who's to testify in favor or anybody who's against. I see one person. Welcome, Mr. Moore, who's here neither for nor against.
Hi, good afternoon, Dr. Claxton, Representative Meyer, members of the Health and Human Services Committee. My name is Dan Moran, Director of Government Affairs and Communications for the Maine Medical Association. Live in Gorham, born and raised in Lewiston. Hello, Representative Craven. I don't see Representative Connor here, but always have to recognize my hometown representatives and senators. Sorry, Senator Claxton, you're across the river.
I know.
So we're neither for nor against. We have no opinion on the bill, but some of you may be familiar. 9 of you were on the committee last session and were part of a hearing in July when Gordon Smith from the governor's office and the former executive director of the Maine Medical Association came in and talked to you about 2117, which was a much more comprehensive PMP bill, which would have expanded the PMP to non-controlled substances. That was a lot of detail, a lot of nuance, but there was something in that bill that was meant to correct something in the law that treated hospital-based medical directors differently than independent community-based physician practices, most notably the larger practices. So we contacted the Veterinary Association when we saw this bill in title and said, hey, do you have any objection to us putting in a quote unquote friendly amendment before the committee? Catherine was very receptive and appreciated us contacting her, and we definitely appreciated her not minding that we come forward and hopefully see if we can tuck this into the bill. And I believe that they contacted Senator Moore too, because I wanted to make sure that we didn't ambush her bill. So thank you for that, Senator Moore. So this simply, I'm not going to read the testimony, you can do that. But this simply would allow chief medical officers from larger independent physician practices such as Intermed, Martins Point, Spectrum, Lewiston Pediatrics, whatever it may be, to access the prescription monitoring program in the same capacity that the chief medical officer of Maine Medical Center or Central Maine Medical Center or Reddington Fairview can check the prescription monitoring program for the prescribing practices of their clinicians. The goal is to appropriately oversee and supervise prescribing so that there's no misuse, and work with providers to change prescribing habits or seek alternatives if they see a problem with the prescribing practices and the patient's prescription load. I'd be happy to answer any questions, and we know we're kind of laying ourselves at the altar here. If there is any consternation by any member on the committee whatsoever, we will walk away and pull this away and try and go for it in the second session.
Thank you for your testimony. Are there any questions of Mr. Moore?
Oh, and before, I'm sorry, Senator, but I also, for Anna's sake, I have links to the previous law, and I have the sections on the back of my testimony that we would need. The bottom section is the only substantive section. The top 2 sections, they come directly from 2117. They'll needed to be put in definitions of law, but they're not substantive. It's only the bottom paragraph on page 3 that we're looking to do, the added language. Thank you, sorry.
No, that's fine. Thank you. We want to do it right. Any information we can get is helpful. Yes, Representative Perry.
When you talk about larger practices, do you define what that is?
You know, again, Representative Perry, you know better than anybody. We're willing to work on it. I don't know what that is, but it's certainly not, you know, Dr. Schiff Slater down the road that has 2 physicians at his practice. They're not going to be looking at each other. It's more for the, you know, Dan Loisel's of the world, the CMO of Intermed, to be able to work with his clinicians.
So we need to have some sort of a definition, it sounds.
Absolutely, and we'll work with you with whatever you deem appropriate.
All right. Are there any other questions? That'll conclude testimony on LD 799. Do we have any questions, since I forgot to ask for the last bill or two, to go to our analyst in anticipation of the work session? I don't see any, so we can proceed. Thank you, Dr. Cole, for being here. And now we can move on to LD 822. And I understand, Senator Keim is here. Welcome. As is Representative Falkingham. We'll start with Senator Keim, if you're there to unmute and introduce LD 822.
Good afternoon, everyone. Apologies as I pull myself together here. Jumping from one committee to the next is always a bit of a trick. Yep. Jumping in and out of Zoom meetings. Thank you for hearing this bill today. I am Senator Lisa Keim, and here to present LD 822, an act to affirm that food seeds are a necessity in Maine. Good afternoon, Senator Claxton, Representative Mayer, and members of the Joint Standing Committee on Health and Human Services. I'm proud to represent the citizens of Senate District 18, which includes Northern Oxford County and 2 communities in Androscoggin. I'm here today to speak in favor of LD 822. And as unusual as this may seem, I'm actually excited to be bringing this legislation before you today, and proud to be sponsor of legislation that was brought to me by a Mainer who is devoted to proper stewardship of our land and our government, Dan Davis. And to help you understand the why behind this legislation, I'd ask for your indulgence as I share a broader story and the valid concerns about the sustenance of life that are somewhat tangentially related to the bill before you today. My family background is one of farming. We are connected to the land and to the seasons, and quite literally to the dirt, preserving it and enriching it so that it may produce healthy, wholesome food for humans and livestock in abundance. However, in my earlier years, I never gave much thought to seeds until stories of genetically modified food began to reach me. Not only does genetically modified food offer questionable nutrient value, but these patented species belonging to mega corporations have also become super spreaders, to the point of them being invasive and cross-pollinating with traditional crops almost uncontrollably and wreaking legal havoc on farmers. Additionally, a decade ago or so, I read a news story about a Russian seed bank that was on the brink of being destroyed to use the fields for housing developments. This particular seed bank, reportedly the world's first, is home to one of the world's largest collections of fruits and berries, including almost 1,000 types of strawberries from 40 countries, 300 varieties of cherries, and almost 900 kinds of black currants, and with 90% of its varieties not found elsewhere in the world. During World War II, during the siege of Leningrad, 12 scientists starved to death rather than eat the grains stored at this agricultural station, barricading themselves inside their vaults to save the seeds for the future of humanity. As the siege dragged on for 900 days, one by one, these heroic men started dying of hunger, refusing to eat the seeds that could have sustained their own lives. Seed banks act as a botanical Noah's Ark, ensuring that the world has access to genetically diverse crops, and they act as a hedge against future threats like climate change, drought, insects, and war. However, large-scale seed banks are not the only location where preservation of seeds is taking place. Many Maine farmers care passionately to develop species and to preserve seed, especially the seed of our heritage varieties. For instance, John Bunker of Palermo was awarded the 2019 Commissioner's Distinguished Service Award for his years of identifying and cataloging the vast diversity of apple varieties that exist in the state of Maine, which has resulted in the living genetic bank created by these hundreds of different apple varieties. While this bill has nothing to do with seed banks or genetically modified seeds per se, these connections help us recognize the global value of preserving seeds and ensuring our right to access. This bill does not seek to burden the state in any way or require the state to take action on providing or securing seeds for our citizens. In fact, the state's only role may be simply to encourage people to grow their own food, as it is more nutritious, better for the environment, and more economical. This legislation is simple. It seeks to establish the right of Maine people to save, swap, share, and obtain seeds without interference from the government. The access to food seeds should not be infringed upon. During the early years of the pandemic, some states, such as Michigan, blocked customers for shopping for food seeds. Governor Whitmer was quoted saying, "If you're not buying food or medicine, you should not be going to the store." I would argue that food seeds were then and should always remain designated as an essential item. So I would urge the committee to pass this legislation before you today, affirming in Maine law that food seeds are essential. And I thank you for your consideration, and I would be happy to answer any questions that you may have.
Does anybody have any questions for Senator Kime? I was curious, Senator, and hope you could speak to, in the summary portion of the bill, it refers to prohibiting profiteering. Does this legislation do that effectively? If that's a prime objective, or is that just a secondary one?
You know, I think it's important, since we would be listing food seeds as a necessity along with the other things that are already in law. I think that is just the right thing to do, to add that in as well.
Okay.
And I would say that it's it may be a little secondary to the object of the bill, but important.
Okay. All right. As long as you're satisfied it'll do what you're trying to do, then the language, then. Okay. Yes, Representative Zager.
Thank you, Mr. Chair. And Senator Kime, it's great to meet you virtually face to face. I know we've had a conversation or two.
Yeah, so nice to see you as well.
So my question is about language in the bill. In section 2, I see the insertion of seeds. Your testimony was regarding food seeds. I'm just wondering if the language matches that, or if this is seeds for any agricultural product.
Yes, Representative Zager, thank you for the question. That's a good one, and one that we actually had talked about a little bit, and then thought maybe it was best to leave it for the committee to decide, and left it sort of open. But food seeds is the intent. But if we leave it open to seeds, maybe that's good as well. But if you want to add food seeds and to clarify, I would be open to that.
Thank you
Does that
very much.
answer your question?
Yes, it does, Mr. Chair. I appreciate it.
Great. Yes, Representative Meyer.
Thank you, Mr. Chair. So this bill is here before our committee based on the fact that we are seeking to add seeds as basic necessities in the law governing general assistance, municipal general assistance, correct?
Yeah, and that is part of the department's hesitation around this bill is the placement. So I don't know that there's a better place for it, because this is where we're describing what we consider to be basic necessities. But the complication that arises from that, obviously, is then the department is saying, well, does that mean that we need to provide this for people? And that isn't the intent. So I think, Molly and I had a short back and forth over email and had agreed that maybe we should talk about language, and if there's a better a better way to portray the intent.
Okay, thank you.
Yeah, because there's a bunch of things in that section that aren't regulated technically by DHHS. So maybe it does fit there, but I appreciate the question. Yeah. Are there any other questions of Senator Kime? I don't see any. So thank you again for introducing the bill. We look forward to the work session and maybe some information from you, your conversation with Molly Bogard. Okay.
Sounds good.
Great.
Thank you.
And we're also joined by Representative Falkingham. Welcome, sir. I'm not hearing you. Maybe. I don't think of you as soft-spoken, but maybe you were there. Go ahead. I think we're seeing a picture of you and a human lobster, but we're not hearing anything. You want to log back out and log in again? Why don't we take a break for about 8 minutes, come back at 1:51, and maybe Representative Falkingham can have figured out the connection issues. We can hear from him. So we'll be back at 1:51. So this is a stand up and move around break, which we should be doing anyway. Oh, Representative Falkingham, are you back with us? Still no audio. Okay, we'll be back at 1:51.
Say something, Representative Fockingham, and bring check. Sound check. No. Can't hear you. Check your volume on your computer. Because I know when I've turned my speaker down, then you can't hear anything.
Representative Fockingham, did you check your settings? I don't know if that would make a difference or not.
No.
Just yell real loud. We'll hear you.
You can always dial in as well if you need to. I don't understand.
Do you want to call in by phone? You can dial one of the numbers on a cell phone and just talk to us that way if you want. Well, that's frustrating.
Yeah.
Uh-huh. So
Maybe
we
Carrie
can't
can-
get him heard, huh?
Maybe Carrie could send him the phone number with the meeting ID so he could dial in.
Yeah, Carrie's going to get in touch with him.
Okay, cool.
So for those of you who are just joining us, we're trying to get one of the people who wants to offer testimony hooked up into the committee. This is today's version of our electronic challenges. So far, it's only been one time, but the day's still young. We're working on it. Has Representative Brennan joined us for the next bill? I don't see him here either. So apparently, our clerk has sent a phone number off to Representative Buckingham. I can hear knuckles cracking, Representative Fockingham.
Am I sideways or am I correct?
You're sideways, but that's better than the way it was before. Well, now we can hear you. There you go.
You want me to go now?
Now you're vertical and audible. The floor is yours.
Okay, thanks. Boy, that's awful. So anyway, good afternoon, Senator Claxton, Representative Meyer, and members of the Committee on Health and Human Services. I am Representative Billy Bob Fockingham that you've patiently waited for. Here to speak in favor of LD 822, an act to affirm that food seeds are a necessity in Maine. This bill adds seeds to the definitions of necessities in the law prohibiting profiteering during supply disruptions and basic necessities in the law governing municipal general assistance. The ability to purchase or have access to seeds could literally be the difference between survival or starvation. If you believe, as I do, that the right to grow food for your own survival is a right that must be fought for and protected, then I hope you will also agree that seeds should be listed as a necessity that is protected from profiteering in times of supply disruptions. Fertilizer is already listed as a necessity under the law, along with tools, utensils, implements, machineries, and equipment to grow food. But what good are these things without seeds for the crop? This bill also adds seeds to the list of basic necessities in the laws governing general assistance. This section already lists food, potable water, clothing, shelter, fuel, electricity, non-elective medical services as recommended by a physician, non-prescription drugs, and a telephone for emergencies. Adding seeds to the list is a logical decision considering seeds literally produce the food. Thank you for your time and consideration. I'll answer any questions you have.
I'm sorry that was so difficult for you.
Me too.
You more than I. Are there any questions for the representative? And you think the language of the bill, the way it's written now, would protect against the profiteering element? I'll come back to that same question I asked Senator Kime.
I do, yes.
Okay, all right. Okay, so there not being any other questions, well, thank you for your persistence. And we'll wrap up. I don't see anybody else testifying for, and I don't see anybody testifying against, or neither for nor against. So we'll conclude the public hearing portion of LD 820. Oh, Senator Moore.
I just want to point out to the committee that they may want to take a look at the department's testimony because it does explain some things about the general assistance program and SNAP as well, as they address the bill. So I think it's important that we make reference of that.
Thank you very much.
Sure.
So we'll conclude the public hearing portion of LD 822. Is there any information we'd like to have available for the work session that we can direct towards our analyst? Yes, Representative Zager.
Thank you, Chair. I guess I'm interested in the definition of food in statute.
And does that definition exist anywhere else in the statute? Yeah, okay.
I know Michael Pollan has written a couple of books about it, but I'm wondering what the law says.
Okay. Representative Craven?
Mr. Chair, I guess I was wondering why this bill didn't go to agriculture, and maybe that I could get an explanation for that.
Representative Meyer, do you want to speak to that?
ACF did not wish to hear this bill due to the general assistance aspect of it.
Because, yeah, it's nestled in the GA statutes.
It's and the implications for what it means to our municipal general assistance administrators.
Are there other questions? Okay, I don't see any, so I think we're all set with 822. That'll allow us to move to LD 910, and there'll be a bit of a pause here while we allow Representative Brennan to get out of one committee and into the next. in this current arrangement, it's certainly a shorter traveling distance. It's just a larger hassle factor to get from one meeting to another.
True.
Welcome, Representative Brennan.
Well, thank you very much, Senator Claxton and Representative Meyer and members of the committee. And I'm pleased to be back before you again so quickly. And I don't think this will be the last time this session, but it's always a great opportunity to come and see members of the committee. I'm very pleased to submit LD 910 for your consideration today. I have submitted written testimony, but I will not go through that at this particular point because I know that the committee has already spent a bit of time addressing this issue. And I want to thank Senator Baldacci for crafting an amendment that I know that was part of your report to the Appropriations Financial Affairs Committee that fairly succinctly and directly addressed this issue of the 90% reimbursement for general assistance. For those of you in the committee that are a little bit younger than I am, just a historical footnote, the 90% reimbursement was actually passed by the legislature back in the late 80s, early 90s. And it was consistently applied to general assistance reimbursement for those municipalities that went over valuation of 0.003 until 2015. And at that time, the legislature and the administration changed the 90% reimbursement and did an across the board 70% reimbursement. So the current law, the current reimbursement for municipalities is at 70%. And again, I'm sure that you heard from Senator Baldacci and others, the importance to communities such as Lewiston, Bangor, Portland, and those that serve as regional service centers, why the 90% reimbursement is both fair and warranted. And again, I'm sure Senator Baldacci has already made these points, but across the state, and I mentioned in my testimony, we run a homeless shelter in the city of Portland. Yet almost half, if not more, of the persons that stay at that homeless shelter are not residents of the city of Portland. They come from other parts of Cumberland County and other parts of the state. And again, I am not quibbling with the fact that we run that emergency shelter, but we also recognize as a state that we're not going to build an emergency shelter in Bridgeton. We're not going to build one in Millinocket. We're not going to build one in a number of other parts of the state. And we accept the fact that Bangor, Lewiston, and Portland do have an array of services related to housing and to food that are not available in other parts of the state. And that's why the 90% reimbursement is a fair approach to those communities that have well-developed general assistance programs. The one question I guess I would ask of the committee, in 910, the bill, this goes back to 2019 when the bill was first submitted. We also make a provision for 100% of general assistance reimbursement for Native American tribes in the state of Maine. And the reason it's 100% is because there's not an evaluation to attach to the tribes. So the 0.0003 does not apply. So in my bill, there is the provision which would allow for 100% of reimbursement for general assistance for Native American tribes in the state. I don't know if you included that in Senator Baldacci's amendment, but I would urge you to somehow, either through that amendment that you made in the report to the Appropriations Committee and my bill, ensure that that provision is also included. So thank you very much, and I'd be more than happy to answer any questions that you may have at this point.
Senator Baldacci?
Yes, I just want to thank Representative Brennan because I know he's had a long career in public service, both with the city of Portland and in the State House, and obviously great minds think alike. This is obviously
in this case, that's true.
And obviously it reflects that it is a very important issue for larger service center communities Portland, Bangor, Lewiston, but also other service center hubs around the state, because the general assistance burden really isn't borne by smaller towns. It's usually the larger cities that have the services, as Representative Brennan said. The amendment we did include 100% for the tribes, but I think it's important that we, in addition to the amendment, that we pass this law to make it permanent and to make sure this policy change occurs, because I think this is another area of multiple areas where we can provide some relief to local communities instead of having the burden on the local property tax payers. So I really appreciate everything you've done in general, but I appreciate your work on getting this resolved. So thank you.
Well, thank you. Thank you. And
Are there any questions, Representative Brennan? I don't see any. So I guess you can get back to one of your other committees.
well, I have multiple ones to choose from, so thank you
I
very
understand.
much. And have a good day, and I look forward to seeing you either in the work session, and I believe I might have one other bill that's coming your way as well. So thank you very much.
All right. Are there any questions or information that we'd like to direct to requests that we'd like to direct towards Ms. Broom? I don't see any, so I think we'll have all the information we need for the work session, at least that we know of right now. That'll take us to consideration, well, the end of the public health, the public hearing on LD 910, and now we'll go to public hearing on LD 1064. Yes.
Thank you very much.
Ms. Withy.
Thank you, Mr. Chair.
Wait a minute, Ms. Withy had her hand up first.
Sorry.
Yeah. Yes, thank you, Senator Claxton. I just wanted to let you know that 3 of the 6 individuals signed up to testify for 1064 aren't here. Would we like to take a few minutes and I can reach out to them and see if they plan to join us?
I did send out an email, but I didn't think that Representative Brennan would be done so quick.
Yeah, that sounds fine. If you could do that, Ms. Withy. Yeah, electronically, this saves you ring around all over the campus in Augusta, but it's a hassle to jump from meeting to meeting to meeting.
So while we were waiting, I'd like the committee to know that this bill is amended slightly. And I think that Anna had sent the amendment, I'm hoping, out this morning or this afternoon, so that, because I think the speakers that are going to be coming after me are going to be, referring to the bill in its amended form.
Okay.
Representative Craven, will you be submitting your testimony online so that we can have a copy of it?
Oh, you didn't get that?
No,
No.
not, and the one this morning as well. We didn't get either one of those.
No, thanks.
Thank you.
I did send out the amendment. I don't have her testimony, but I sent out her amendment.
Yes.
Yeah, I've got the amendment, but I didn't have
Oh,
her
I'm
testimony.
sorry. Okay.
Yeah, that was at 9:43.
Yeah, I got the amendment. I just didn't get the
I'll send it out.
testimony. Yeah.
Okay, well, we have a couple people here who want to testify. So if Representative, welcome everybody. If Representative Craven wants to start by introducing the bills, this will be a good time to do it.
Thank you, Mr. Chair. Good afternoon, Senator Claxton, Representative Meyer. I see I'm calling you Meyer now. And fellow members of the Health and Human Services Committee. My name is Margaret Craven, and I represent House District 59, which is part of Lewiston. I'm pleased to be in front of you today to introduce LD 1064, an act to advance palliative care utilization in the state. Palliative care is a medical approach that can begin when the patient is diagnosed with a life-threatening disease or major illness that can occur simultaneously with a person's treatment plan. The purpose of palliative care is to prevent and relieve suffering of a patient and their family, which includes physical and mental suffering. Palliative care is both a medical specialty and a team-based approach to the care of patients living with serious medical illness. Palliative care offers an additional layer of support to patients experiencing the realities of their disease and treatments. It offers excellent pain and symptom management, emotional and spiritual supports, and perhaps most importantly, accept conversations regarding wishes for future care. Integrating palliative care into the treatment plans of all patients with serious illnesses like advanced cancer, heart disease, lung disease, or dementia has become the standard of care. Unfortunately, most patients in Maine who need palliative care do not receive it. The primary barrier to the delivery of palliative care is that there is no reliable, sustainable reimbursement for palliative care under the Maine Care program. Palliative care is a definition, interdisciplinary and team-based, that reimbursement models to support this care must be developed if patients are ever to receive the benefits from it. LD 1064 directs the Department of Health and Human Services to provide reimbursement under the Maine Care program for palliative care. It further directs the department to adopt rules, although this is part of the amendment, and that you will see in the amendment that was forwarded to you. Thank you for your time, and happy to answer any questions.
Thank you for bringing that bill forward. And we did get the amended version, which includes yellow highlights
Yes.
earlier this morning. Okay.
And we can thank Lisa Harvey McPherson for the nice highlights.
Great. So next we'll go to Lori Belden. Welcome.
Thank you so much. Good afternoon. My name is Lori Belden, and it's a pleasure to be here. I'm a 20-year resident of Durham, and I also serve as the Executive Director for the Home Care and Hospice Alliance of Maine, with a trade association for home care, home health care, and hospice providers across the state. Palliative care is patient and family-centered services that provide an interdisciplinary team approach to pain and symptom management. I think most people are familiar with, but it also provides emotional, practical, social, and spiritual support. Palliative care can also be provided at any stage of illness, from diagnosis through end of life, which really makes us a natural complement to the home care and hospice services that our members provide. I really want to thank, I've lost Margaret, there she is, Representative Craven, for putting forth this amendment. I think I told her yesterday I'm a little timid in working with legislators, and she was very responsive and understanding, and I really want to thank you for putting forward this amendment, which we at the Alliance fully support. We applaud the amended bill's requirement to establish reimbursement rates for palliative care, the interdisciplinary team who deliver this vital care to Maine Care beneficiaries. And instead of reinventing the wheel, it also relies on the National Coalition for Hospice and Palliative Care Clinical Practice Guidelines for Quality Palliative Care. Say that 10 times fast, to shape the rules for reimbursement. So my testimony is short and sweet. We just really want to thank Representative Craven and throw our support behind the amended version of LD 1064. Thank you so much.
Any questions for Ms. Belden? Okay, so a quick one in the palliative care world in Maine. Who else should be included in a stakeholder group? The amendment specifically references the Home Care and Hospice Alliance and Maine Palliative Care and the Quality of Life Advisory Council. Is that a broad enough representation of that community?
I'll ask Lisa to follow up, but I do think it is. The palliative care group that's mentioned along with the Alliance includes a multidisciplinary, I think it includes a hospice council and several other, I think even a few people that are delivering hospice care services. I think that was already established in statute, looking at Lisa for a nod, that particular group. So that's already a pretty diverse group there. So my opinion is yes, but maybe Lisa's looking it up right now.
Yep.
Okay, thank you. A good question.
Thank you, Ms. Belden. Any other questions for Ms. Belden? So we can go to Ms. Harvey McPherson when she's ready and not doing research. Thank you, though.
Yes, good afternoon. Senator Claxton, Representative Meyer, and members of the Health and Human Services Committee. My name is Lisa Harvey McPherson, and I am here to speak in support on behalf of Northern Light Health in favor of the sponsor's amendment. And I want to thank Representative Craven for amending her bill. And we are in full support of establishing an interdisciplinary rate for palliative care services. In my testimony, I talk about palliative care. My sense is that you've had a number of briefings on palliative care. We provide palliative care in hospital, outpatient, and in-home settings. Our team is comprised of doctors and nurses and social workers and therapists, truly an interdisciplinary team approach. The amendment that has the highlights in yellow, I'll explain the changes to you. Section 1 of the amendment simply is the statute that exists today that is the legal definition of palliative care. Because the rule would refer to that definition, I thought it would be helpful for the committee to have that definition in the amendment. The Section 2 of the amendment has the existing section that establishes a reimbursement rate for interdisciplinary palliative care. And it also directs the department to establish rules using national evidence-based practices, which Lori referenced. And it also takes the stakeholder group that was in the former bill and puts it into this section of the bill to advise the department on educational materials that are intended to inform both consumers and providers about the main care reimbursement and the interdisciplinary approach. I do have before me the Advisory Council, the Palliative Care and Quality of Life Advisory Council appointees, and I see doctors. I see a number of palliative care doctors. I see palliative care professionals. I see pharmacists. I see an insurance representative. I see a social worker. I see statewide organizations such as the American Cancer Society and the Primary Care Association. So it is a good representation. And the Home Care and Hospice Alliance of Maine is also listed. A recent trend, although not exclusive, but a recent trend is for hospice and palliative care programs to offer home-based palliative care programs. I know that's the model that Androscoggin Home Care and Hospice has launched. That's the model, one of the models that Northern Light has. So that's a bigger component of growth in palliative care is when it's offered through home care and hospice programs. And so that's why that organization was added. And with that, I welcome any questions that you have.
Are there any questions of Ms. Harvey McPherson? I don't see any. Nope. Glad you could be here. Thank you.
Thank you.
And Terry Lacasse. You want to unmute and share your testimony? Ms. Lacasse, are you in the group? You're still unmuted and we can't see you. You're still muted and we can't see you.
I should be unmuted.
There, that's unmuted. That's good.
Okay, they want to start okay. There. Hi.
Welcome.
Good afternoon, Senator Claxton and Representative Meyer and members of the Health and Human Services Committee. My name is Terry Lacasse. I'm a resident of Brunswick and a volunteer ambassador with the American Cancer Society Cancer Action Network. I also represent the American Cancer Society and Cancer Action Network on the Palliative Care Advisory Council. I'm a retired employee of the American Cancer Society, and I'm a nurse by training. I'd like to thank you for this opportunity to submit the following testimony in support of LD 1064. Palliative care is a growing field of specialized medical care that improves the quality of life and patients and their families by focusing on relief from pain, stress, and other often debilitating symptoms of treatment for a serious disease such as cancer. Palliative care is appropriate at any age and any stage of a serious or chronic illness and can be provided alongside curative treatment. It's delivered by trained specialists who work together with doctors and nurses in a team-based approach that focuses on the patient's needs, explains treatment options, and gives patients and their families a voice in realizing their treatment goals. More than 10,000 people will hear the words, "You have cancer," this year in Maine. From the moment a patient hears these life-changing words, all the way through treatment and beyond, they cope with pain, stress, side effects from treatment. Pain, nausea, worry, and other symptoms and side effects of cancer and its treatment are not an inevitable consequence of cancer. They typically can be controlled. Numerous studies have demonstrated the benefits of access to palliative care, improved quality of life, improved patient and caregiver satisfaction, reductions in emergency department visits and intensive care days, and typically overall cost savings. Despite the benefits, thousands of patients diagnosed with serious illness have no idea that palliative care is available to them and are not offered access to these services. This was the case with my family member who was diagnosed with stage 4 lung cancer. Upon diagnosis, he was provided a list of next steps that consisted of many tests and appointments with specialists. He quickly became overwhelmed and stressed with the weight of the diagnosis, the long list of tests and appointments, and all the medical jargon. I accompanied him to his medical appointments and suggested a referral to palliative care, knowing its potential benefits from my training as a nurse and long career with the American Cancer Society. He received a referral for a single visit with a palliative care provider. While this appointment was beneficial, I knew this was far from the extra layer of support he needed. It was not
30
best
seconds,
practice.
Ms. Cass. 30 seconds.
And was, thank you, and not best practice palliative care. I tried my best to fill in by helping him navigate this journey and supporting him emotionally. However, palliative care is not my field of training, and I can point to many ways in which his cancer journey would have been less stressful and his quality of life would have been improved had he had access to palliative care throughout his cancer journey. This story is not uncommon. Passage of LD 1064 would take steps forward by improving patient and provider education about palliative care, ensuring the full spectrum of palliative care services is covered for Maine Care members. By focusing on Mainers and Maine Care coverage and public and provider education, the bill has the potential to help decrease disparities in access to palliative care. The written testimony submitted online provides citations to the research showing the benefits of palliative care and recommends a technical language addition if you choose to move forward with the bill. Please vote in support of LD 1064. Thank you.
Thank you, Ms. Lacasse, for your testimony. Are there any questions? I don't see any. Thank you again for being here. We've been joined by Ms. Powell. Ms. Powell, do you have some testimony you want to offer in support of LD 1064?
Good evening, Senator Claxton. Thank you so much. It's a pleasure to be here as always, and I really admire the work and the testimony that I have heard so far from my colleagues. Again, good afternoon to you, Senator Claxton, and to Representative Meyer, and all the members of the committee who I know want to ensure and make sure that patients and families receive the type of care that will help them remain at home and will help them deal with the complexities of their illness. Advanced chronic illness, someone with many comorbidities, the complexities are great. The complexities of family dynamics are great. And the complexities of symptom management are often great. They deserve the attention of members of an efficient, effective, knowledgeable, experienced interdisciplinary team, as you've heard from other members who have testified. And this bill focuses on the reimbursement model for all members of the team. But more importantly, it also increases the service delivery in the communities for people that would like to age and die in place or deal with their advanced illnesses in place. So there are many dimensions to LD 1064, and the Maine Hospice Council is certainly in great support of the bill. As you know, we did a market survey in 2016, and we are repeating the market survey this year to update and evaluate the number of palliative care services and the quality of those services. And the data will be available to everyone in the state for whatever reason they choose to use it to develop their own programming. So what we do is shared with everyone. And I'm sure it'll be very helpful to the providers in the state. So I'd like to end with this story. 2 days ago, I received a call from a family. People often call our office. They know they need something, but they don't know what they need. And so I take the time to have them tell me their story. And then hopefully I'm able to provide and suggest some resources in their area that they can tap into. The story was complex, as many stories are. And what the upshot of it was, the mom was in the hospital. She was going to be discharged. And they went to one of the staff and asked if there were palliative care services available so the mom could receive them at home. There were two things that came up in the conversation. One was that the individual they spoke to knew nothing about palliative care, nor any resources in the community. So I think this highlights, Lisa was talking. Yes, Lisa was talking about the need for education. And so I think you see many elements that this bill will encompass, and I encourage you all to support LD 1064. And thank you, Representative Craven, for being our champion.
Thank you, Ms. Powell. Are there any questions that you'd like to direct her way? I don't see any. Thank you again for being here.
Thank you.
So I don't see anybody else who's testifying for or against, or neither for nor against. So that will conclude the public hearing portion. Is there any information that people would like to have available for the work session? Yes, Representative Craven.
Thank you. I don't need any materials, but Molly had sent an interesting letter, and I hope that the committee would look at it. And if you didn't get it, I can forward it to you. But I think that she put it in the portal.
It would be interesting to know too, what other states have done about this. Are we the last of the states to adopt this kind of treatment and reimbursement for our Medicaid programs, or are we the first? And
We are not the first. California. Oh, go
yeah,
ahead.
I knew the answer to that part, but I didn't know the answer to the latter part, the former part. Okay, so yeah, just to have a perspective would be helpful. Any other questions? Okay, so that'll conclude our work today on LD 1064. So now we're going to turn it over to Representative Meyer, because I've got to testify. Mine will be very short and sweet.
So we welcome the sponsor of LD 1069, an act to provide program solvency, clarity, consistency, and flexibility in routine public health licensing activities. Senator Claxton.
Thank you and good afternoon, Representative Meyer and fellow members of the Joint Standing Committee on Health and Human Services. I won't bother to reintroduce myself since we've already done that a number of times and you just heard the title. I will say that there are at least a half dozen changes in section of statute that are being asked for related to public health licensing in this departmental bill. And since I can't speak knowledgeably to any of them, I'm going to defer to representatives from the department to explain the rationale for the requested changes. I've already heard some negative feedback from somebody, but we'll wait and see if somebody can walk us through the many changes in this particular piece of legislation. So thank you for the opportunity to introduce LD 1069. And I defer to the chair.
Thank you, Senator. Here to testify from the department is Lisa Silver. Welcome.
Thank you, Representative Meyer. Thank you, Senator Claxton, for sponsoring this bill. Appreciate it. Senator Claxton, Representative Meyer, and members of the Joint Standing Committee on Health and Human Services. My name is Lisa Silver, and I'm the Program Manager for the Division of Environmental and Community Health Inspection Program. I'm here today to introduce and provide testimony on behalf of the Maine Center for Disease Control and Prevention, and will be speaking in support of LD 1069, an act to provide program solvency, clarity, consistency, and flexibility in routine public health licensing activities, a bill presented by the department. The following information is offered for your consideration. I will describe the proposed changes by topic area in the order that they are presented in the bill. Section 1, the bill proposes to repeal 22 MRS 2175. The Maine Wild Mushroom Harvesting Certification Program has been defunct since its inception in 2011. Due to the lack of interest among stakeholders, the committee was never established and regulations related to this program were not finalized. Section 2, this bill proposes to amend 22 MRS Chapter 562 by changing the chapter title to include public pools and spas, sporting camps, and lodging places. This change will update the chapter's title to be consistent with 2011 and 2013 legislation that added requirements for these additional establishments. Section 3 and 5, the bill proposes to amend 22 MRS 2491 subsection 1 to clarify compensation by replacing either directly or indirectly with including indirect compensation. A definition of indirect compensation has been proposed in section 5, subsection 7G, ensuring that there is consistency in licensing determinations. Section 4 and 6, the bill proposes changes to establish criteria to differentiate between a lodging place and a permanent residence by amending the definition of lodging place to specify a maximum length of stay and further clarify that lodging places are associated with the hospitality and tourism industry. The department currently licenses approximately a dozen establishments that are more appropriately classified as rooming houses or permanent residences. The appropriate license will ensure that applicable protections and due process are afforded for any resident with respect to a landlord-tenant law. In section 6, LD 1069 proposes to amend 22 MRS 2491 subsection 10C to add a definition for permanent residence to distinguish these locations from other establishments that require HIP licensing, as there is currently no definition of permanent residence in statute. The addition of this definition will support the proposed lodging definition that establishes criteria for length of stays. This change will further clarify licensing criteria and provide guidance for licensing determination for specific establishments. In the 129th second regular session of the Maine Legislature, the department worked with Hospitality Maine and the Maine Campground Owners Association on LD 2063 to clarify the lodging definition's length of stay and agreed on stays that are temporary in nature, consisting of fewer than 183 days in the aggregate per year. This work is reflected in LD 1069, submitted to the committee for this session. This definition coincides with state tax laws in Title 36, Chapter 801, 5102, 5B, for resident individuals who maintain a permanent place of abode in this state and spend in the aggregate more than 183 days of the taxable year. Section 7, this bill proposes to amend 22 MRS 2491 subsection 11 to further clarify the definition of recreational camp or sporting camp. The current statutory definition does not specify the number of rooms required for licensure, which has caused confusion for applicants. Because recreational camps and sporting camps are types of lodging places that fall under the broader rules specific to lodging establishments in 10-146 CMR, Chapter 206, 4 or more rooms or cottages must be rented to require licensure. Additionally, the current definition is silent on the service of food to guests of the camp, which differs from service of food to the general public and requires a different type of license. Generally, recreational camps and sporting camps provide food for their guests, in addition to lodging, as part of the service offered by the establishment. Sporting camps receive 2 inspections, one for lodging and one for food safety. This bill will clarify these 2 issues by adding the number of rooms required for licensure and specify that food service is for camp guests only. Section 8, this bill proposes to amend 22 MRS 2491 subsection 16 by removing summer sports to allow any program overseen by employees or volunteers of municipalities and educational institutions and taking place on the property of municipalities and educational institutions to take place without HIP licensure. Section 9, this bill proposes to amend 22 MRS 2491 subsection 1 to clarify compensation by replacing directly or indirectly with including indirect compensation. The definition proposed in this bill specifies that indirect compensations means a non-monetary compensation. Section 10, this bill proposes to amend 22 MRS 2491 subsection 3 by adding regardless of fees changed to further clarify that a campground consisting of 5 or more tents or RVs is presumed to be receiving compensation for its use. A license will be required for all camping that meets the definition of campground. This change will alleviate confusion for owners of campground businesses and entities that hold events for a fee and offer event camping at no charge. Section 11, the bill proposes to amend 22 MRS 2494 by adding public pool and spa to the list of license types. This license type was inadvertently omitted from this section when this chapter was amended in 2011. Section 12 and 15, LD 1069 proposes to amend the conflict regarding municipal fees in 22 MRS 2494 and 2499 to clarify fees for an establishment to operate in a municipality with delegated authority that requires local inspections. 22 MRS 2494 currently requires $60 for each application for any of these establishments. And section 2499 subsection 6 requires that fees set forth in 2494 be waived and prohibits charges exceeding $100 to support the cost of licensing, training, and providing technical assistance during investigations and legal interpretations. Section 13, LD 1069 will allow greater flexibility for applicants when conditional licenses are issued and will also limit an applicant to only one conditional license. The applicant must meet the terms of the conditional license to be issued an annual license. This clarification is necessary to help applicants understand that they will not receive multiple conditional licenses unless previously cited conditions are met. In addition, applicants must pay all late fees, additional inspection fees, and fines before the issuance of any license. Section 14, the bill proposes to remove the existing and second or subsequent fines for unlicensed operation in 22 MRS 24981C and replace with a penalty not to exceed $5,000 for any person, corporation, firm, or co-partnership that operates without an active valid license. In addition, 22 MRS 24982 allows the department to establish a schedule of penalties according to the nature and duration of the violation. Section 16, in contrast to the Department of Agriculture, Conservation, and Forestry, the department lacks clear statutory authority to detain or embargo food in its licensed eating establishments. LD 1069 is proposing to add Section 2503 to correct this oversight, which will allow health inspectors to detain, embargo, or condemn food where there is reason to believe the food is adulterated or misbranded. And last but not least, Section 17 through 39. This bill proposes to update sections of Title 32 relating to tattoo, body piercing, micropigmentation, and electrology to 1, collect late fees, additional inspection fees, and fines before the program will issue a new or renewal license. 2, allow issuance of conditional licenses to body artists. 3, add existing micropigmentation criminal factors to all other body artists, including electrologists, tattoo artists, and body piercers. Identical language is proposed for each body artist type to be consistent with the micropigmentation language already in law. 4, the program has authority to set standards for inspection of body artists, but does not have the authority to right of entry. This bill proposes to include the same language found in 22 MRS 2497 to permit the program's health inspectors to enter the business premise of any licensed body artist to determine compliance. This bill proposes to specify that inspections or other compliance reviews will be conducted at least every 2 years. And 5, clarify the definition of micropigmentation to be consistent with industry standards of placing pigment under the skin and not the subcutaneous portion of the skin. This clarified definition will now include microblading, which is not currently licensed by the department. Based on our research, the department estimates there are at least 60 persons and/or shops practicing microblading in Maine. There are concerns about education and training, qualifications, proper facilities, and sanitation. Revising the definitions would also make Maine consistent with other states that are licensing microblading as either tattooing or micropigmentation. In summary, the Maine CDC respectfully recommends this bill ought to pass. LD 1069 proposes to make several important changes and clarifications to Maine's laws pertaining to health and safety that will assist the department in applying laws fairly and consistently for its licensees. We appreciate that this committee unanimously supported a version of this bill last session without enough time to get it through the chambers prior to adjournment, and the work of the numerous stakeholders to agree to the language proposed. Thank you for your consideration of this matter and for the opportunity to provide testimony today. And I can just address any questions from the committee, and I will be available at the work session. Thank you.
Thank you for that comprehensive overview of this bill. Questions from the committee for Ms. Silva of Maine CDC? Seeing none. Senator Nate Libby was to testify. I have not seen him appear. Doesn't seem to be here, so we will go to.
As long as he's not here, maybe I will ask one question of Ms. Silva. One of the things that would help me in the multiple parts of this is to understand who's going to consider themselves a winner in related to these changes and who's going to consider themselves a loser. And because it sounds like some of the application process may be easier, that the definitions may be more standardized. I can see some real advantages there. But without understanding the impact of all of these rules, I don't know who's going to feel that they're not getting a fair shake. And if you could figure out some way to help us understand who's going to feel unsettled by any of these changes, that would be helpful to me.
Sure. I mean, most of these things are just correcting things that were omitted from previous, like 2011, adding pools, public pools and spas, and the head notes. One of the biggest, or maybe the most controversial, is the lodging place definition, and some landlord owners feeling that, you know, this bill would conflict what they're trying to do. And so I'm sure you may hear from some landlords about this, from rooming houses or boarding homes. We do not, you know, our program does not inspect those. They're permanent residences, and our program really has oversight and authority for the tourism, recreational type industry. So like hotels and motels, things like that.
Okay. That helps. Thank you.
Okay, sure.
Any other questions for Ms. Silva? Seeing none. Up next is Gregory Dougal of Hospitality, Maine. Mr. Dougal. Hello. Welcome.
Sorry about that, Representative Meyer. I didn't expect to be up that quickly. Senator Claxton, Representative Meyer, distinguished members of the Health and Human Services Committee, my name is Greg Dougal. I do represent Hospitality, Maine, and our over 1,000 lodging and restaurant members. I am here to speak neither for nor against. I think Ms. Silva, as to the portion of this that refers to us, did a great job of explaining what occurred last year. But originally, the bill had 90 days as the threshold for a permanent residence. Our issues were specifically with Section 4 and Section 6, which were the definition of lodging place and the definition of permanent residence. We did get together, as she mentioned, to discuss what an appropriate number would be. I did poll my membership. Again, my membership is mostly transient lodging individuals licensed by her department. The issue became that we had people who are staying longer lengths of stay, like many things I've heard in this committee today, traveling health professionals, people like that stay a lot longer than 90 days, but don't really stay much longer than 6 months. And so that seemed to be a spot that we were able to be comfortable with. And that's pretty much it. You know, we stand by what we said last year, and we're willing to move forward. I think it is critical to say, like Ms. Silva did, that a lot of these this is about the licensed community and Health and Human Services, and they don't license the people that I think are concerned about this. So just a thought, and I thank you for your time. Happy to answer any questions.
Thank you for your time. Any questions for Mr. Dougal? Seeing none.
Thank you.
That concludes who has signed up for testimony on 1069. So I'll ask the committee if there are any requests for further information from our analysts for the work session. Seeing none. I believe that completes our work for today.
I have one very quick amendment review, if you would indulge me to do that.
Certainly.
Very fast one. I just have to pull it up, and it is here. So this is Meals on Wheels, and I just want to draw your attention to line 16. This is literally the only, although it's a strikeout and replace, it is literally the only change is this line 16. If you'll remember, the account was incorrect in the original bill. And so everything else is the same, but I wanted you to see it so that I could shoot that one out the door because it's ready to go.
Thank you.
That's all.
So that does conclude our day. We will be back tomorrow at, I believe, 9 a.m. We'll be here at 9 a.m. for a work session on LD 118. And unless there's anything else from the committee, I I would entertain a motion to adjourn.
So moved.
So moved. Second.
Second.
All in favor?